So this is the DV calendar.
Okay. Yeah.
Hello, good morning.
Good morning. How are you?
Out ready to go, or we need more time?
Thanks, man.
In a minute. Okay, wait, so something new, another issue?
No.
Okay,
This is, so this works a little different than one doing. One was a anyone who's camera on the ground. This is a webinar. Works a little different. People with risk, promoting the analyst. Which means they had to do the camera video. Audio video. Usually, challenge for the Q&A functions. I get one every day.
okay.
Like if everyone was experienced.
Well, I agree, yeah, no, okay, so as of right now, I see interpreters, I see Mr. Matheny, I see Francesca Sarmiento, and that's about all that I see. Okay,
Good morning, Your Honor. How are you? Do you also see Miami Beach?
thought I heard somebody.
Yeah.
Good morning, Your Honor. This is Joanne Hennessy from the city of Miami Beach. I'm here for the misdemeanor calendar, so I'm just listening to the DV.
All right, so did we place the private counsels out of turn or no? Not of.
It's up to you, Your Honor.
Well, like I always accommodate, I don't know if we can do it. Who's Ms. Sarmiento, are you a private counsel as well?
Good morning. Yes, Your Honor. I'm here with Mr. Matheny.
Good morning, Your Honor. How are you?
Good, thank you. What is the case?
Your Honor, we have Jillian Bentley on the felony calendar, Eric Matheny and Francesca Sarmiento on her behalf.
Yeah, I thought you were on the DV calendar. Yeah, we got a while for the felonies to go. We were stuck in juveniles and dependencies due to some Zoom issues. So it's going to take a while. So I would suggest getting a cup of coffee or something.
Okay.
The felonies.
We'll stand by. Thanks.
Thank you. All right, let's go to the domestic violence division calendar. Yes. Okay.
I'll be ready to go once I announce to the court through a microphone.
Got it. All right, go ahead.
Thank you.
Okay.
I'm so sorry that I'm a lot smoother.
Don't worry. I'm easy. Oh, wait, you know what? It's saying that I'm not. It looks, everybody can hear me, it sounded like, because it's saying to join with computer audio, but I guess I'm okay.
Guys, apparently there's a sergeant from Miami Beach that you're gonna have to let him in.
We're ready, Judge.
Okay,
Sar-
thank,
Sergeant Rodriguez is asking to be promoted.
You just put it in the wrong place.
Judge, we're ready.
okay. All right, if I can have the defendant sworn.
Damas y caballeros, por favor, pónganse de pie y levanten sus manos derechas.
Please raise your right hands.
Levanten sus manos derechas. El que está en la silla de ruedas no se tiene que levantar.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please say I do.
Juran solemnemente que el testimonio que nos rendirán será la verdad y únicamente la verdad.
All right, good morning, folks. My name is Judge William Altiel. This is the Domestic Violence Division calendar. The public defender will be appointed provisionally on all cases unless otherwise noted. And the court is going to be addressing each case individually. And we start off with Olga Carvajal Calderon. Okay, you, ma'am?
Señora Carvajal, ¿habla usted inglés?
I feel, yes.
Does she need the interpreter?
Well, I prefer it.
You know what, and for the record, let's just go ahead and swear in the court interpreter for this proceeding as well.
Madam Interpreter, do you swear to interpret from English to Spanish and from Spanish to English to the best of your ability?
I'll try not to be a madam interpreter, but yes,
sorry.
I speak Spanish. I am
All words,
qualified. David Marte, certified court interpreter. Good morning, Your Honor. Good morning to everybody.
My apologies.
No, it's okay. It's my raspy voice.
All right, you are charged, ma'am, with one count of domestic violence battery and also violation of a domestic violence injunction. I do find probable cause.
Señora, usted se le acusa de agresión corporal de índole de violencia doméstica, pero también a usted se le acusa de haber quebrantado un interdicto por violencia doméstica. Su señoría ha determinado que hay motivo fundado ante dicha acusación.
And I am going to issue $1,500 bond on both counts.
Su señoría va a emitir fianza de 1,500 en ambas acusaciones.
And ma'am, you are to stay away from Alberto Gonzalez. You cannot have direct contact or indirect contact.
Yes, sir.
Señora, usted tiene orden de alejamiento del señor Alberto González. Usted no puede tener contacto directo con él ni contacto indirecto con él.
Your Honor, I would ask for a standard bond of $1,000 on count one and a reduced bond of $500 on count two. There is no injunction number given for count two. And additionally, she does tell a story of self-defense to police when they arrive.
Su abogado de oficio está pidiendo que ponga fianza de rigor de solo $1,000 por la violencia doméstica y que le imponga solamente $500 por quebrantar el interdicto, ya que no hay un número en el interdicto, además de que dice que usted le dijo a los policías que se estaba defendiendo a sí misma.
My issue is she had a pending stay away order. She had no business being there, whether it's self-defense or not. She should not have been in that close of proximity with the victim.
Mi problema es el siguiente, y ella tenía un interdicto, ella no tenía, ni aunque se estuviese defendiendo, ella no tenía, ni podía estar ni siquiera cerca de la víctima.
So it is $1,500 each count. I am also going to have a GPS monitor. She will be, it'll be level 3, waive costs and installation.
Señora, son $1,500 en cada acusación, pero además va a tener una tobillera electrónica nivel 3, pero le van a exonerar los costos y la instalación. Usted ya se puede marchar.
Your Honor, is house arrest an addition to the bond or an alternative? I'd ask that it's an alternative.
It's going to be in addition to it, but she will be roaming.
Pero su abogado de oficio está preguntando si el arresto domiciliario es una alternativa o es además. Su señoría dijo que es además, pero como es nivel 3, usted puede merodear.
The next case I have is Patricia Williams.
Disculpe, deambular.
And Your Honor, if the state may, we would be asking for an elevated bond in this case as well due to the history of priors, including felony aggravated battery. Or sorry, felony aggravated assault rather, as well as felony child abuse, aggravated child abuse.
Any of these domestic violence related and or with this same victim?
Same thing. They are domestic violence. Some of the parties are domestic violence related. I do not think they're with the same victim though.
Your Honor, I'm gonna be requesting pretrial services. Miss Williams is here on a walker. I don't believe she's a danger to anyone. The
Sure.
laceration was minor in this case, and her priors are very remote in time.
She does not qualify for pretrial services.
Yeah, I'm gonna give $1,500 bond.
Your Honor, would you consider giving a standard bond of $1,000 instead?
To me, I don't have standard bonds. I know that there are guidelines that the court can utilize, but when there are allegations of battery, especially with these specific allegations, I think $1,500 is actually the minimum that I would be giving. So over defense objection, it's $1,500. And ma'am, you can have no contact whatsoever with the alleged victim, Gregory Grace. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate with Gregory Grace. You understand that, ma'am?
Yes, sir.
Luck to you.
Oh, my apologies. For the record, was probable cause found? I don't know.
Yeah, I said probable
Yeah,
cause found.
Thank you.
Thank you. Thank you, ma'am.
And we go to Karen Garcia.
Do you hablo inglés? Miss Garcia needs a Spanish interpreter.
Okay. All right, Ms. Garcia, you are charged with 1 count of battery domestic violence.
Señor García, usted se le acusa de agresión corporal de índole de violencia doméstica.
The court does find probable cause.
El tribunal ha determinado que hay motivo fundado,
There'll be $1,500 bond.
$1,500 de fianza.
And ma'am, you can have no contact with Enrique Lopez during the pendency of this case.
Señor, usted no puede tener contacto alguno con Enrique López durante la dependencia de este caso.
You can have no direct or indirect contact. You cannot call, write, text, use social media, or communicate through a third person.
Usted no puede tener contacto directo con él, no puede tener contacto indirecto, no lo puede llamar, no le puede escribir, no le puede mandar mensajes de texto, no puede utilizar medios sociales para comunicarse con él, ni tampoco puede utilizar terceras personas para comunicarse con él.
You need to go back to the home to get personal belongings.
Usted necesita volver a esa casa o a ese sitio a buscar sus cosas personales.
Es mi casa.
It's my house.
Well, you're going to need to, if you need to go back there, I will allow you to go back to get your personal belongings. For right now,
Si usted necesita volver, su señoría le va a permitir para ir para recoger sus efectos personales. Él vive ahí también.
but it has to be with the assistance of a law enforcement officer.
Pero cuando usted vaya a recoger sus efectos personales, usted tendrá que ir con un agente del orden.
All right, good
Your
luck.
Honor, would you consider a reduced bond? Miss Garcia is the one who calls the police officers based on the arrest warrant and tells them she was attacked first.
Señoría, por favor, usted puede reducir la fianza. La señora fue quien llamó a los agentes del orden y ella les dijo que él la atacó a ella primero.
I'm going to respectfully deny that request based upon the allegations of biting the victims.
Con todo respeto, yo voy a denegar esa petición debido al alegato de que hay que ella mordió a la víctima. And he bust my tooth, I believe she said, Your Honor.
Okay.
Está bien.
Yo no soy agresiva, él ha estado aquí antes por agresivo.
I am not aggressive and he's been here before.
You don't, Mr. Fender, we need Miss Estevez next.
Correct.
Ok, señora, por favor, váyase porque ahora viene otro acusado. Gracias.
Yeah.
Thank you.
Yes, only English.
Okay. Your Honor, I'm going to be asking for a reduced bond in this case. She has no priors and the arrest form reads as mutual combat. I'm going to be asking for a bond of $500.
Your Honor, state wouldn't necessarily object to a reduced bond, however, as to mutual combatants, would point out the affidavit states all three parties stated the defendant was the first to make the physical strike and the defendant was found to be the primary aggressor.
All right. Ma'am, you are charged with 1 count of domestic battery. The court does find probable cause. I am going to issue a $1,000 bond. You can have no contact whatsoever with Elena Van de Vinder. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate through a third person. Do you understand?
Yes, I understand.
Now, with respect to going back to the residence to get your belongings, do you need to do that?
Yes, I do.
Okay, so I will allow you to do that with the assistance of a law enforcement officer to accompany you in retrieving the items. Good luck to you, ma'am.
Thank you.
Karen Ruiz.
Ms. Ruiz requires a Spanish interpreter.
All right, ma'am, you are charged with 1 count of battery.
Usted tiene una acusación de agresión corporal, señora.
Your Honor, Ms. Ruiz has no priors. I'd be asking for a reduced bond of $500 in this case.
Su señoría, la señora Ruiz no tiene antecedentes penales. Yo estoy pidiendo que reduzcan la fianza a solo $500. Oh.
Is the victim a minor?
La víctima es menor de edad.
No, era mi pareja.
You
No,
don't
it
need to,
used to be my partner.
No, Your Honor.
because they have initials here, and I was wondering.
Just invoke mercies.
Okay. All right, the court does find probable cause,
Este tribunal ha determinado que hay motivo fundado
and you have no priors?
y ella no tiene antecedentes.
All right, there'll be a $1,000 bond
La fianza se la van a reducir a $1,000.
order. You can have no contact whatsoever with JR. Do you know who JR is?
Usted no puede tener contacto alguno con la persona con las iniciales JR. ¿Usted sabe quién es JR? Señora?
No.
She doesn't, Your Honor.
All right, well, there is someone who is alleged to be the victim in this case, whose initials are JR. You don't know.
La persona que es la víctima en este caso tiene las iniciales de JR.
No,
No,
no. El nombre es Emerson Ruiz.
his name is Emerson Ruiz.
Sí.
All right, is he also known by the name of Jose?
Pero él se llama José Emerson.
Yo lo conozco por Emerson Ruiz.
I've only known him as Emerson.
Well, his legal name is Jose Emerson Ruiz, but we can amend the stay away order.
Su nombre legal es José Emerson Ruiz, pero la fiscalía va a hacer una enmienda para incluir el primer y segundo nombre.
So I'm going to include on the stay away order the initials ER. Do you know who that is now?
Pero entonces ahora usted conoce ER. Ese si usted sabe quién es.
Sí.
Yes, sir. Yes.
You have no contact whatsoever, no direct or indirect contact. You cannot call, write, text, use social media, or attempt to communicate through a third person.
Que usted no puede tener contacto directo ni indirecto con él, usted no lo puede llamar, no le puede hablar, no le puede mandar mensajes de texto, no puede utilizar los medios sociales para comunicarse con él, usted no puede utilizar terceras personas para comunicarse con él. ¿Usted entendió?
Entendido.
I've understood.
All right, now, do you need to go back to his residence at all to get any personal belongings?
Usted tiene que ir a la casa de él para buscar algo.
Tengo dos motos dañadas, el cual él las iba a reparar.
Okay,
Pero las
perfecto.
tengo que
Yeah. I
recoger.
have 2 old motorcycles that he was supposed to fix them, but he hasn't fixed them.
Well, that's not personal belongings, but if you did have any, you can do it, but you have to do it with the assistance of a law enforcement officer. A motorcycle is not a personal belonging.
Bueno, señoría no considera las 2 motocicletas efectos personales, pero si acaso tiene que buscar, tendría que buscarlo con un agente del orden.
Okay.
And I just want to
Okay.
bring to the court's attention, I don't believe this should be in DV unless rules have changed, as they don't reside together. They haven't been in a romantic relationship for over a year, and they have no children together.
Su abogado de oficio está alegando, 1, ustedes no viven juntos. 2, no tienen niños pequeños. Y 3, ustedes no tienen una relación romántica ya hace más de un año.
All right, the state is to look into that to see if in fact,
Yes, Your Honor.
Su señoría ha comentado que la fiscalía debe de indagar a eso para ver si eso es correcto.
yeah, it
El
may
fiscal adjunto está de acuerdo.
And that is,
look like it's a non-domestic violence, so it shouldn't be.
Para su señoría le parece que esto sería un caso que no involucra violencia doméstica, sino violencia sencilla.
Okay, let's go to
Ustedes pueden
Soraya.
marchar, señora.
All right, ma'am, you were charged also with battery, domestic violence.
Buenos días, ¿hablas inglés? You speak English?
Yeah, she speaks English.
All right, the court's reviewed the arrest affidavit. Finds probable cause.
Your Honor, she has no priors, so I'd ask for a standard bond of $1,000.
that's correct.
There's 2 counts, so what I will do, I will make each count $500. And with respect to the stay away order, you can have no contact whatsoever with Nia Cyprus and Landon Cyprus. You cannot have any direct or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate through a third person. Do you understand, ma'am?
Yes, sir.
Now, you need to go back to the residence to get any personal belongings.
Yes, yeah, she does.
All right, so I'm going to allow you to do that within 48 hours. You need to do it with the assistance of a law enforcement officer accompanying you, okay?
Okay.
Thank you. Mike, is it Michael or Michelle Pimentel Tavieso?
And Your Honor, the defendant does have prior domestic violence related conviction.
He needs a Spanish interpreter.
All right, sir, you are charged with 1 count of violating a domestic violence injunction, trespass after warning, and loitering or prowling.
Señor, usted se le acusa de quebrantar un interdicto de violencia doméstica, se le acusa de entrada ilegal tras previo aviso, también se le acusa de merodeo.
The court finds probable cause.
Este tribunal ha determinado que hay motivo fundado
Your Honor, I have a PC argument if you can entertain it. I don't see that they indicate anywhere within the four corners of the arrest form how many feet he was required to stay away from the property. It could be 50 feet for all we know.
Su abogado de oficio está indicando que ella tiene un argumento de motivo fundado. Dice que no hay ningún sitio donde se diga cuántos pies de distancia usted tenía que estar de la propiedad y que podía haber sido solo 50 pies.
All right, the court does read the defendant what they're saying he was in violation of condition number 4, which the court finds from the four corners of the affidavit means that he did violate that particular component of the injunction. So it is respectfully overruled as it relates to your objection. And the defendant it'll be $1,500 on count 1. On count 2 will be $500. And on count 3 will be $500. In addition, there will be a GPS level 3 roaming.
Your Honor, when you said number 4, you said, was it a condition or an article or a paragraph? What was it?
Condition number 4 of the stay away.
Thank you. Sí. Su señoría está denegando la petición o pedimento que hizo el abogado de oficio adjunto a favor suyo. Él está indicando que una de las condiciones que se menciona es la condición número 4, que usted quebrantó la condición número 4 y por ende él entiende que usted quebrantó la orden de alejamiento del lugar y le está imponiendo fianza $1,500 por la primera acusación, $500 la segunda acusación, $500 la tercera acusación.
And again, sir, I'm going to advise you, you need to stay away from this location if you are released. It's 2258 Northwest 28th Street. You cannot be within 500 feet of that location.
Disculpe, señor. Además, su señoría le impuso una tobillera GPS nivel 3 y le va a encargar de nuevo. Usted tiene orden de alejamiento del 2258 Northwest de la 28 calle y tiene que estar mínimo a 500 pies de distancia de ese lugar.
Your Honor, the GPS, it's plus or an alternative.
Sure, he understands. Did you understand that, sir?
Señor, ¿usted está entendiendo la orden de alejamiento? Señor.
Dígame.
What?
Did you understand the stay away order that you cannot be within 500 feet of that location?
Señor, ¿usted entendió la orden de alejamiento que usted tiene que estar a más de 500 pies de distancia de esa localidad?
Pero si yo no...
But it said I no longer...
Ahí la señora con que yo tuve problemas no, ya no vive ahí, ya no trabaja ahí ya.
The lady that I had issues with there, she doesn't even work there anymore.
You're not listening.
Usted no me está escuchando.
Ordering you to stay away from that location. You can't be within 500 feet. Do you understand that?
Señor, es que usted tiene orden de alejamiento de ese local. Usted no puede estar ni siquiera a 500 pies de distancia de ese sitio. ¿Usted entendió?
Ya no estoy allá.
I'm no longer there now.
Do you understand that you can not go back there?
Pero usted entiende que no puede volver por ahí, señor.
Yo no tengo dónde más ir.
I have
Yo no tengo
nowhere else
familia,
to
ni tengo
go.
nada.
That part I did not understand. He was mumbling.
You're not going to be complying with the court's order?
Entonces, si usted no está en cumplimiento de la orden de este tribunal,
Are you going to comply with the court's order to stay away from that location?
señor, usted va a tener cumplimiento con la orden de este tribunal de alejarse de ese lugar.
All right, the court's going to be elevating the bond to $5,000 for count 1, $500 for count 2, and $500 for count 3 with the GPS level 3 roaming.
Su señoría va a elevar la fianza, en vez de 1,500 será $5,000, acusaciones 2 y 3, $500 cada uno, y con la tobillera electrónica tipo GPS, pero será que usted puede deambular con esa tobillera.
Okay, thank you.
Ok, gracias, señor. Se puede marchar, señor.
No.
Se puede marchar, señor.
No, he's good. You don't need a Spanish interpreter?
No, I'm good.
All right, sir, you are charged with 1 count of battery.
Yes.
Your Honor, he has no local prior, so I'm just asking for a standard bond of $1,000.
All right, the court does find probable cause. Does he have any priors?
He does not have pressure.
All right, sir, I'm going to make it a $1,000 bond. You are to have no contact whatsoever with Jamia or Jamia Allen. That means no direct or indirect contact. You cannot call, write, text, use social media, or attempt to communicate through a third person. Do you understand, sir?
Yes, sir.
Now, with respect to any personal belongings, I don't know if you're currently residing together. Do you need to go back to the apartment to retrieve any personal belongings?
Yes.
All right, I'm going to allow that within 48 hours with the assistance of law enforcement to accompany you. You will be allowed to do that. Good luck to you, sir. Juan Torres. All right, sir, you are charged with 1 count of battery and 1 count of resisting an officer without violence to his person. Court does find probable cause. Count 1 is, what kind of priors do we have?
So, Your Honor, defendant does have extensive criminal priors, including as recent as 2022, a felony crim miss. He had a felony in 2005 for strong arm robbery. He had a
Any
felony.
previous with either of these victims?
No, Your Honor, does not appear.
Your Honor, I'd like to point out that the alleged victim isn't the one who contacted police. She even told the police not to hurt her son, that he had mental health issues.
Understood. All right, the court is going to, on count 1, $2,500 bond. On count 2, $500 bond. And sir, you can have no contact whatsoever with Magali Reyes Marrero. That means no direct contact or indirect contact. You cannot call her, you cannot write her, you cannot text or use social media or attempt to communicate through a third person. Do you understand that?
Yes, sir.
Now, do you need to get any personal belongings out of the home?
Maybe a few little things.
Okay, so I'm gonna allow that. Within 48 hours, you can go there, get whatever you need with the assistance of a law enforcement officer. Good luck to you, sir.
What, in 48 hours, you said?
You got 48 hours from your release, yes.
Okay, so meet today or tomorrow? Or 2 days after, yeah. Okay.
2 days after our bond, though?
Yes.
Okay.
Okay, Malik Miton or Miton.
He's present before Your Honor.
Good morning, sir. You are charged with 1 count of battery domestic violence.
Morning.
Your Honor, Mr. Mighton has no local priors. I would ask for a standard bond of $1,000 and then the alternative pretrial services.
What do you have?
Your Honor, while that's correct, he does not have local priors. I would object to pretrial services. The allegations in this case are serious. The victim is a juvenile who suffers from autism. And according to an independent witness, the victim was thrown to the ground and punched in the head by the defendant.
I would just point out that the witness tells a different story than the victim himself.
Court does find probable cause. It is going to be a $1,500 bond. Stay away order as well from IM. Sir, do you know who IM is?
Yes, yes, sir.
Have no contact whatsoever with IM. That means no direct contact or indirect contact. Cannot call, write, text, use social media, or attempt to communicate through a third person while this case is pending. Do you understand that?
Yes, Your Honor.
Now, as far as where you're staying, if the victim is staying in that location, you're going to have to find another place to stay. Do you need to go back and get any personal belongings?
No, no, Your Honor.
Okay. All right, sir. Good luck to you.
Thank you.
Maxo Marty. All right, so you are charged with battery, domestic violence. Court finds probable cause.
Your Honor, I'd ask for a standard bond of $1,000. Mr. Marty has no local priors.
That's correct, Your Honor.
All right, it'll be $1,000 bond. And you are to have no contact whatsoever with Angie Marty. That means no direct contact or indirect contact. You cannot call, write, text, use social media, or attempt to communicate with Ms. Marty through a third person. Do you understand, sir?
Yes, sir.
Now, with respect to your personal belongings, you need to go to the home where she may be staying to get some personal belongings.
No, we live different country. I live in Dead County, she live in Broward.
Okay, sir. Good luck to you.
Thank you, sir.
You could bond out.
Hetuan McKenzie.
Oh, I see.
Sue.
I see.
All right, Mr. McKenzie, you are charged with battery.
Your Honor, I'd be asking for house arrest level 3 for Mr. McKenzie. He has a job. He's employed. I'd also point out that the alleged victim wasn't truthful with the police about there being a restraining order, so I don't know how credible this person is.
Vacancy with the government. What does the state have?
As far as priors, Your Honor?
Yeah.
There was actually a felony grand theft that was just null prost. So he has no convictions or withholds on
Here
it.
is the same victim.
He did have an M24 battery.
Judge, she also has 2 new felony DV cases on your bond hearing calendar.
Oh, that's right. Yes, he had the F25 11085. So
Same victim.
let's see. Just kidding.
All right, I'll tell you what, I am finding probable cause. I'm gonna, give it a $2,500 bond with a stay away order from Jasmine Henry. You are to have no contact whatsoever with Jasmine Henry, no direct, indirect, you cannot call, write, text, use social media, or attempt to communicate through a third person. Do you understand, sir?
Yeah, that's on each case, Judge, 2,500 each case.
I only have one count. Wait,
No,
you have two?
There's two cases, one count each.
I'm sorry, hold on. Now I see the two. Okay. 1 second. So when, May 9th, and when did this one occur? May 16th, I see. Two instead of three. All right, I'll tell you what, so let's make it $1,500 on the M25-11353 with the stay away order. And the court also has reviewed M25-11352, finds probable cause. You are also charged in that case with battery. And the stay away order is on for Jasmine Henry. Do you have a second stay away order?
We are making a copy right
Okay.
now.
Do you understand, sir, the stay away order, you can have no contact whatsoever with Jasmine Henry, direct or indirect?
Yes, I do, sir.
So the 11352, also $1,500 with the stay away order. And I didn't hear what you said. Did you need to go back to get any personal belongings?
I got a couple things there, but I was moving out anyway. I was moving out yesterday, but she called the police on me. That's why I'm gonna get arrested. So,
well, in any event, I'm going to initial it that if you do want to exercise that right, you can do it. You got to do it within 48 hours with the assistance of law enforcement to get those belongings from the apartment.
okay, that's good, sir.
I'll speak to you at the felony bond hearing. That's the second one, okay? And then we go to Elias Vicente Pu.
Mr. Vincent Pu requires a Spanish interpreter.
You are charged with one count of violation of a domestic violence injunction.
Pero usted se le acusa de quebrantar un interdicto de violencia doméstica.
Court finds probable cause.
Este tribunal ha determinado que hay motivo fundado.
What kind of priors?
¿Qué tipo de antecedentes tiene él?
He has an open resisting without violence misdemeanor charge. He had a felony, but there's no action.
What kind of felony?
It was an aggravated assault.
And who is the victim? Does it show domestic?
It does show domestic.
And
Está indicando que usted tiene un delito menor abierto, pues resistir un arresto pero sin violencia, pero también está indicando el fiscal que usted tuvo un delito mayor de agresión con agravantes que fue desechado y dice que con la misma víctima.
all right, so the court, as I mentioned, finds probable cause. You are to stay away from DR. Do you know who that is?
Señor, este tribunal ha determinado que hay motivo fundado. Usted tiene orden de alejamiento de la persona con las iniciales D de David, R de Rafael, DR. ¿Usted entendió?
And you understand?
Yes.
All right, sir. You can have no contact, direct or indirect. You cannot call, write, text, use social media, or attempt to communicate through a third person.
Señor, usted no puede tener contacto directo ni indirecto con ella. Usted no la puede llamar, no puede hablar con ella, no le puede escribir, no le puede mandar mensajes de texto, no puede utilizar medios sociales para comunicarse con ella y tampoco puede utilizar terceras personas para comunicarse con ella.
Your Honor, before you set bond, I have argument to make. The stay away order is from the case ending in 274. I have been the attorney of record on that case. It's a resisting without violence. So I don't know how appropriate it is for there to be a stay away order against this person in that case. I would ask that you take that into account and issue a reduced bond of $500.
Su abogado de oficio está indicando que la acusación que usted tiene pendiente es de resistir un arresto sin violencia y que ella no entiende de dónde ni cómo sale la orden de alejamiento y por ende ella está pidiendo que te reduzcan la fianza. You said the 500 or 1,000?
500.
A solo $500. I'm sorry.
I'm going to allow the state to respond. It's not a question of 500. It's a question of release outright if there's no probable cause. So, because again, if that's not the right case, then we don't have PC for the domestic violence injunction. So we're here
Your Honor,
for
may I? Okay. So the aggravated assault, as we mentioned with the prior, that was no action, but it's the same victim. The the resisting without was associated with it. When it was no action, the resisting had a separate case number, but it all stemmed from the same initial conduct, which was a alleged battery against the victim.
All right. So with that representation, I will still find probable cause.
Ok, el fiscal adjunto está indicando que inicialmente fue agresión corporal con agravantes y luego se redujo a solo resistir al arresto sin violencia, pero que aún así la agresión corporal con agravantes fue con la misma víctima. Ahora bien, su señoría, tomando en cuenta eso,
And I am going to issue a $1,500 bond with a GPS level 3 roaming.
su señoría va a emitir una una fianza de $1,500 con tobillera GPS y con derecho a deambular.
Your Honor, would you consider making the GPS alternative? This alleged victim, she did not contact the police. She doesn't want a stay away order to the best of my knowledge.
Le están pidiendo a su señoría que en vez de la fianza de 1,500 que haga la tobillera electrónica tipo GPS como una alternativa porque la supuesta víctima no llamó a la policía y ella no quiere la orden de alejamiento.
Not at this time.
No por ahora.
Let's go to the next case, Chasari Randolph.
¿Puede hablar un poquito?
May I speak a little bit?
No, not at this time.
No, no este momento dado.
I'll give you a number to contact your attorney.
Yo le voy a dar un número de teléfono para que usted se comunique con su abogado o abogada, quiero.
It's in here.
All right, so you are charged with battery. Court's reviewed the arrest affidavit, makes a finding of probable cause. What kind of priors?
Your Honor, in 2023, there was a conviction for felony third degree grave theft.
Okay, is it domestic related?
No, that was not.
That's it?
And in 2015, a felony cocaine possession.
Okay. All right, sir, you are to stay away from Angelina Jackson. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate through a third person with her. Do you understand?
Understood, Your Honor.
All right, now with respect to getting any personal belongings, do you have any belongings where she's residing?
Yes, sir.
All right, so I'm going to allow you to get whatever belongings you need within 48 hours from your release with the assistance of law enforcement. It'll be a $1,500 bond with the stay away order. Good luck to you, sir.
Thank you, Your Honor.
Okay. Continuing with Elier Bello or Bello.
Requires a Spanish interpreter.
Can I speak?
Better do not speak about the facts of this case.
Lo mejor es que usted no hable sobre los hechos de este caso.
All right, what kind of priors?
¿Qué tipo de antecedentes tiene?
All right, in the meantime, while they're looking, the court's reviewed the arrest affidavit, makes a finding of probable cause.
Mientras tanto, su señoría ha repasado el informe de arresto y ha determinado que hay motivo fundado.
Your Honor, there was a battery. It was domestic violence related. It was from 2008, however, so I wasn't able to access a copy of the arrest affidavit in that case in our system. So I could not tell if it's the same victim.
2008 or 18?
2008.
And it looks
Su
like it was
señoría,
no
sí hay un antecedente de violencia doméstica pre del año 2008. Yo no tengo acceso alguno y no sé si es con la misma víctima.
All
And
right.
it was a no pros.
Su señoría, ese caso fue anulado.
Madam Public Defender, did you say something? I thought.
Yes, I was just pointing out the 2008 case, Your Honor. It was dismissed. It wasn't a conviction.
It was completed, they completed the PTI court order.
Got it. All right, I'm going.
Fue que usted completó un programa de intervención.
I'm issuing a stay away order. You would have no contact with, and I don't know if I can pronounce this, Iseli Trujillo Alvarez.
Usted no puede tener contacto alguno con la señorita Iseli Trujillo Álvarez.
No direct or indirect contact. You cannot call, write, text, use social media, or attempt to communicate through a third person.
Usted no puede tener contacto directo ni indirecto con ella. No la puede llamar, no puede hablar con ella, no le puede escribir, no le puede mandar mensajes de texto, no puede comunicarse con ella a través de medios sociales, ni tampoco puede intentar comunicarse con ella a través de terceras personas.
You understand that?
¿Usted entendió, caballero? Señor?
Sí, pero puedo decir algo.
Yes, but can I say something?
Yo tengo un niño
I have a sick child.
Okay.
y yo soy el que lo cuido y tengo que
I'm the one who
cuidado,
takes care of him.
que se está muriendo en el hospital y yo soy el que lo
He's
cuido.
dying
lo
at the
curo,
hospital.
Tiene problemas en el corazón, en los riñones y de
He
todas
has heart
formas
issues. He
tenemos que
has kidney
comunicarnos de
issues.
alguna forma porque está muy enfermo.
I have to have some contact with her because he is very sick.
Your Honor, can we make the stay away order that they can have contact only about their child in common?
Llevo 5 años cuidando.
I've been taking care of him for the last 5 years.
I will allow a third party to facilitate either any type of transfer of the child or any type of issues, but I do not want them to be together to discuss this child. They have to do it through a mutually agreeable third party, but they still cannot be near each other. It can only be communications either on the phone or some other type of communications. But I am issuing that stay away order and it is only from her. It is not from the child.
Porque usted tiene únicamente orden de alejamiento de ella. Su señoría está indicando que no se podrán comunicar ustedes directamente a través para hablar del niño, pero que ustedes entre los dos tienen que buscar a alguien y para eso le va a permitir que se llame. Va a buscar a alguien que le facilite ser un intermediario para la comunicación de usted hacia ella y de ella hacia usted, pero usted tendrán que buscar a alguien que ustedes ambos estén de acuerdo que sea el intermediario.
All right. Do you need to get any personal belongings from the home?
Señor, ¿usted tiene artículos personales en la casa que usted tiene que recobrar?
Sí, sí, yo tengo todo ahí. Sí, yo cuido a mi hijo ahí.
I have everything there because I take care of my child there.
Ayer mismo yo vine del hospital que le dieron el alta, llevaba un mes en el hospital y yo estaba con él y ayer recientemente vine a la casa.
Yesterday, I came from the hospital. I was with him. And it's a matter of fact, he'd been in the hospital for a little bit over a month and they just let him out yesterday.
All right. Well, you will be allowed to go back to the home to get your personal belongings with the accompaniment by a law enforcement officer.
Señor, usted podrá volver una sola vez a la casa acompañado de un agente del orden para buscar sus efectos personales.
Good luck to you, sir. Thank you.
Buena suerte, caballero. Gracias.
What was the bond amount, Judge?
$1,500.
La fianza, una vez más, son $1,500.
Actually, you know what? I will reduce it to 1,000.
¿Sabes qué? Le voy a reducir la fianza a solo $1,000.
Gracias.
Thank you.
Yeah.
Ready? Almost. How are you? Hey. Very.
Morning, Your Honor. Is that the end of the DD calendar?
Looks like it.
Yes. Thank you
We
very
did?
much.
Okay, let me start the other one.
I'm here for, this is Joanne Hennessy for the city of Miami Beach. I'm here for the jail arraignment calendar. And also I know Sergeant Rodriguez is on the, one of the attendees, if she could be admitted. She's here for Nicholas Bennett.
Is it interesting?
Thank you.
Your Honor, Sergeant Melissa Rodriguez.
Okay, good. It's still morning? Yes, good morning. So this is interesting. So I'm looking at to the right of the screen. So all of these people are they observing or are they like in a waiting room? Oh, okay. A lot of people observing.
Good morning, Your Honor. This is Lauren Fernandez. How are you?
Good, thank you. Good morning. How are you?
Good. Are you doing felonies next or?
What are we doing next? What's
Misdemeanors.
Misdemeanor. We're doing misdemeanor. We had a little bit of a snap.
Hi, good morning.
For the detention and juvenile hearing, so that set us back about 45 minutes, half an hour. So stand by.
Okay. I put my client's information in the chat. I don't know, maybe the clerk could send me a copy of the A form, possibly.
Take the privates out of turn. I have no problem with that.
Thank you, Your Honor.
Take care. Be well. Good morning. How are you? I'm good. Okay. Thank you.
Hi, good morning.
Good morning.
Hi, Judge Outfield. My name is Isabella with the Law Office of Orlando Rodriguez, PA. We do have a client who was arrested yesterday, and I'm wondering if he'll be on today's calendar, so we can let the family know.
I can only tell you what is brought before me as it happens, so I don't know.
Got it. Well, have you done traffic misdemeanors, or have you not?
Yes. So, what is this?
Okay.
Yeah, we're a bit behind. We had some Zoom technical issues for one of the other calendars.
I heard about that. Okay, so we'll stand by. Thank you.
Ooh, boy, I should hire you. Thank you. Oh, 6:25, 9 a.m. Is that 6/7?
Yes, sir.
Okay. Mistake. I know the back here. I always get confused where to write for the traffic cases. So you
Close it out here.
right.
And you bond out all ours. Things right here.
Okay.
You know, that's on the files. On the form is right here. All your bond out, everything is right here. Okay. And then you can sign this. That's not everything is here.
Okay.
We sign, okay?
All right. Well, so we'll play it by ear. I'm sure by the end of the calendar, I'll have it.
Actually, just let me know if you need me.
Okay. And let me know when everybody is ready to go.
You're ready.
Please. Okay. All right. You want to swear in the?
They were already sworn in, Your Honor.
They were? Okay. All right. Good morning, folks. My name is Judge William Altfield. This is the misdemeanor calendar. And the public defender is appointed unless otherwise noted. The court is going to making probable cause determinations, seeing if cases can be resolved as well. We will start with, I have the first case, Julia Morgan.
Present before the court, Your Honor.
All right, ma'am, you are charged with petty theft and obstruction by disguised person. Reviewing the arrest affidavit.
Your Honor, I would point out that there's not PC for count 2. I could provide case law.
Your Honor, they indicated that but the rest affidavit indicates that they gave several names that were not accurate.
Why is the defense saying that this is not an obstruction?
So your honor, she doesn't disguise herself. I believe the legislator intends this for it to be a disguised person, like concealing your physical appearance. In Leland versus State, which is the District Court of Appeals of Florida, 3rd District, 386 Southern 2nd District, 622. It says a defendant who gave a false name to police officers upon being stopped did not commit a misdemeanor of obstruction by a disguised person. It's just one count. Okay.
Read the entirety of that, but that was just for a stop and not when they're actually being taken into custody, or what were the circumstances?
Your honor, one second. Let me find out for you. It was for a stop in this specific case. But my argument, I still think would remain the same. I believe the legislator intends for this to be a physical appearance disguise.
No rules?
Your Honor, the statute reads, whoever in any manner disguises himself or herself with the intent to obstruct the due execution of the law or with the intent to intimidate, hinder, or interrupt any officer, beverage enforcement agency, or any other person in legal performance of his or her duty or exercise of his or her rights under the Constitution or laws of the state, whether such intent is affected or not, shall be guilty of the first or of a misdemeanor of the first degree. And so, Your Honor, it doesn't seem it's much of a probable cause argument, even as much as it maybe a argument for a C4 motion to dismiss. But the probable cause element is met at the very least by the fact that the defendant gave multiple false names.
I agree. I think that this does fall under the elements that are met for obstruction by disguised person. So probable cause is found on both counts. As to count 1, it will be $1,000. Count 2, $500. And ma'am, you can have no contact whatsoever with a 7-Eleven located at 3199 Northwest 62nd Street. You cannot be within 500 feet of that location. Do you understand?
I understand.
Okay, good luck to you.
And I'm sorry, Your Honor, it was $1,000 for count 1 and $500 for count 2?
Yes.
Okay. Your Honor, would you grant pretrial services in the alternative? She doesn't have any money to pay bond. And her priors are minimal.
Your Honor, she has a prior petty theft from last year, conviction.
Again, they're minimal.
I don't have anybody from pretrial services.
Don't know where this.
So, Your Honor, you could grant it in the alternative, and if they found she didn't qualify, they wouldn't release her, but she'd at least have the option.
We can do pretrial services, and if not qualified, it will be the bond.
Okay, thank you, Judge.
Alternate the bond you stated before, Judge.
1,000, yes, and then 500.
Thank you.
Samantha Martinez. Is this a bench warrant or is this
This is a bench warrant, Judge.
It is. Okay, we'll make this a $500 bond. Was this all on this one?
You lowered the bench warrant amount, Judge?
Oh, I thought it was 500. Wasn't it a $500 bench warrant?
It was $1,000 bench warrant, Your Honor. I was going to ask for it to be reduced. She doesn't have the money to pay any amount, she's telling me. Would Your Honor consider pretrial services for Ms. Martinez?
With the warrant outstanding, I thought it was 500. It's a $1,000 bond. And if this. And ma'am, you are to have no contact with this, this is Samantha Martinez, correct?
Yes, I'm here for the bench warrant. That's what I got arrested for.
You should. You should have a stay away order from the retail theft.
Samantha Martinez, yeah.
Right.
All right, so you should have no contact whatsoever with the Walmart located at,
Yes, I understand, sir. They did tell me.
let me just finish. It looks like 33501 South Dixie Highway, Florida. You cannot be within 500 feet from that location. Do you understand?
Yes, sir, I do.
Okay, good luck to you.
So what's going on?
So you have $1,000
Brianna?
bench warrant. You
So
can
I
call-
won't be getting out?
No, you're gonna have to call the public. If you can't afford that, no, you're gonna stay in jail. So just
For how long?
until you can go get a court date on that bench warrant case. So call the public defender's office and ask for them to get you a court date, okay? Best of luck to you.
Davis.
All right, you can sit in here.
Yeah.
All right, this is Brianna Davis. You're charged with battery. The court's reviewed the arrest affidavit, makes a finding of probable cause.
And Your Honor, I'd like to point out Ms. Davis has no local priors and that she cooperated with the police. I'd be asking for a reduced bond of $500.
Correct. There are no local priors for this defendant.
All right, well, this one I could recommend pretrial services as well. So what I'll do is pretrial services.
Local, do you?
No, I live in
Your Honor,
Michigan.
she lives in Michigan, so I don't think pretrial services, so that's why I'm asking for a reduced bond amount in this case.
I have an aunt that works for American Airlines, so I can.
It'll be $1,000 bond. And a stay away order. Do we have stay away order for somebody? All right, you are to stay away from, well, do you know who DL is? Okay, Miss Davis. Can you hear me?
Yes, Your Honor.
The alleged victim in this case, he goes by the initials DL. You know who that alleged victim is, correct?
He was a bouncer at the beach.
I just want to acknowledge that you know who he is, correct?
Yes, sir.
Okay. You are to have no contact with this individual whatsoever, you directly or indirectly. You cannot call, write, text, use social media, or attempt to communicate with him through a third person. Do you understand that?
Yes, Your Honor.
Good luck to you, ma'am.
Thank you.
Fabiola, Mark? Is Fabiola Mark here?
Not yet, Judge. Hi, how are you doing? We have Miss Mark here, Your Honor.
All right, Miss Mark, you are charged with criminal mischief.
I'm sorry.
Okay, don't make any statements right now, okay? We're just here to get you a bond.
The court finds probable cause.
Huh?
It's going to be $1,000 bond with a stay away order. You have no contact whatsoever with Rose Mark. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate through a third person. Do you
But
want?
how am I gonna see? Can you tell how am I gonna see my child?
Okay.
Can you please
I'll
explain that?
ask him.
Please? Please
Your Honor,
explain.
Miss Mark is homeless. Would you consider in the alternative the TAP program?
What's going on? I don't wanna visit my kids.
She also has a child, I guess, that is with this alleged victim that she wants to have contact with. Would Your Honor let there to be limited contact in regards to the child.
That is the problem with this. This really should have been some type of a burglary charge. It's by breaking in the window. Not sure whether or not she actually broke the plane of that, but that is close to a felony. I'm not going to be giving pretrial services or TAP. It is going to be $1,000 bond with a stay away order. Ma'am, do you understand? You can have no contact with Rosemark. I just need you to acknowledge that.
Please contact me. I don't carry a phone. He's making me come over here.
Mark, listen.
I don't live in Florida. I don't understand what's going on right now.
Take a breath. Do you understand that you can't reach out to her right now?
So why she made me come here? Why
Miss
she made me drive $15 to come here?
Because I am ordering you to stay away from her. If you
I
violate
have a stay away order from her. I want to see my kids.
criminal charges and contempt, do you understand that?
Okay, but can I have ROR? Can I have a right away to stay away from her? She already lost custody of me at 15. It's already torturing me to see her every day. You understand, sir? I'm really a chemo survivor, bro. It's just torturing me to deal with.
Let's go to Cynthia Coronado.
He's done.
What'd you say?
I'll call on the next offending judge.
Yes. Coronado on her way.
They're bringing her in now, Your Honor. Coronado.
Do we have a stay away order from the Walmart on this one? Are you giving me?
Because there was a bench
Señora Coronado, ¿habla inglés?
on
Yes.
this past case, which was from the Walmart. But I did just check our record. We already had a stay away order issued.
We can take that.
Yes. Thank you.
All right, ma'am, you are charged with possession with intent to use drug paraphernalia.
And then the bench warrant will be.
There's also a bench warrant that is outstanding in the amount of $3,000.
I don't know I had a bench warrant.
The court is going to convert the bench warrant to a bond, $3,000.
Your Honor, would you consider reducing that bench warrant amount? It's for a misdemeanor and it's a fairly recent bench warrant from April.
All right, I'll reduce it to 1,500.
Thank you, Judge.
That's on the bench warrant, which is, do we have the case? B252367. And then as to the drug paraphernalia, $500. Okay, anything else on that? Thank you.
What?
Miss Corondo is homeless and she doesn't have money to pay the bond. Would you consider granting her TAP in the alternative?
On the bench warrant? What was the- We need 50. Each, hold on a second. But it said B, where was it? B252367, is that the one we're talking about? Oh, that one.
Yeah.
I thought I put it in.
You did on the other.
Oh, okay, so what was it?
I asked him.
Yeah, okay.
Your Honor, I'm sorry, I don't know if you heard me. Miss Coronado's indicating she doesn't have any money for bond. Would you consider TAP in the alternative?
No, not the bench warrant that was issued. All right, the next case that I have is Lina Ibarra Ramos. All right, ma'am, do you speak English?
No,
Señora, ¿habla español? ¿Habla inglés?
no.
Okay.
All right, you are charged with driving under the influence.
Señor, usted se le acusa de manejar embriagada.
Court reviewed the arrest affidavit, makes a finding of probable cause.
Su señoría está repasando la atestación de arresto y la atestación jurada, disculpe, y el juez ha determinado que hay motivo fundado.
All right, bond will be $1,000.
Fianza de $1,000.
Good luck to you, man.
Buena suerte, señora, se puede marchar.
And then we go to Nicole Cassandra Clark. Or to Sandra Nicole Clark. All right, you are charged with tag not assigned. These are bench warrants?
These are bench warrants, correct,
warrants.
Your Honor.
All right, these were $500 bench warrants. It'll be a $500 bond on case A5L89BP. And then as to A5L89CP, that was also a $500 bench warrant, is $500 bond. I think that's it. Good luck.
Your Honor, would you consider pretrial services for Miss Clark? She doesn't have money for bond. And the bench warrant's fairly recent. It's from May 20th.
It's a $500 bond.
And Your Honor, there was a felony conviction for cocaine possession from 2024, so I don't think they'd be eligible.
Willie Knight, believe he is homeless.
Your Honor, this is Joanne Hennessy for the City of Miami Beach. According to the most recent A form, I believe he has a address in Lauderhill. And this is a warrant. We'd ask for an increased bond to 500. Mr. Knight has several violent priors, including assault with a deadly weapon and disorderly conduct.
Sorry, who are we on?
We're waiting for him to get there. Willie Knight. We're waiting for him to get there.
Do we know? Okay. Do we know what page of the calendar? Oh, I found him. Okay.
He's coming up, Judge.
All right, so was this a bench warrant that was issued?
No, but it's
Because this is from February, okay.
It's a bench warrant, Judge.
Your Honor, yes, Your Honor. It's a bench warrant. It's a $150 bench warrant for camping prohibited. I'm going to be asking for ROR in this case.
Your Honor, he was previously ROR'd and failed to appear. We would ask.
He's not a candidate for an ROR. It is going to be, I'll make it a $250 bond.
Okay. He's still not here, Your Honor.
Oh,
He's coming up.
court does. Do we need to put it on the homeless calendar or how does?
If you had ROR'd him, then we would get a date certain on the homeless calendar.
Your Honor, he has an address on the most recent A form of Lauderhill.
All right, just make sure that the clerk's office has that.
Your Honor, would you consider pretrial services in the alternative for Mr. Knight?
No, ma'am. Not when there's an outstanding bench warrant.
Okay.
All right, there he is. Okay, sir, first of all, you are, have a bench warrant on case number B25-03140. I'm giving it a $250 bond. And I'm also going to, if it hasn't already been given, was there ever a stay away order from that location during those hours? No, I'll leave it as it is. Okay, anything else?
No, Your Honor, I don't see a stay away order, so I'm not sure.
Oscar
But
Gonzalez.
thank you.
You refuse court, Judge. Reset for tomorrow.
Reset, not brought to court.
Refuse court.
Nicholas Bennett.
Your Honor, I know that Sergeant Rodriguez is here for this case. This is.
Yes, good morning, Your Honor.
Oh, okay.
Judge, I just want to make sure that the felony hold that Judge Figueroa placed on him is showing on the jail card.
She placed the hold on yesterday. It's on the jail card.
Okay.
All right, so you are charged with trespass after warning. Court finds probable cause. And you are to stay away from this location, sir. At 109th Street on Miami Beach, Florida. You cannot be within 500 feet of that location. Otherwise, it will be grounds for an additional charge and potentially a contempt proceeding. Do you understand that, sir?
Yeah.
All right.
And Your Honor, I'd be asking for a standard bond in the alternative pretrial services.
He is an open felony. He would not be eligible.
All right, it's going to be $500.
Your Honor, if I may,
Yes, ma'am.
the reason why I'm here is because his violence just keeps increasing. He keeps targeting females in our city in the same area. The first time you want to swear me in? I'm sorry.
Yeah. Go ahead. Somebody swear in the witness.
I do. Sergeant Melissa Rodriguez, Miami Beach Police Department. So he started in March by grabbing a female on Ocean Drive by her shoulder, attempting to hold her down. Then in April, there were two females walking down Washington Avenue and 8th Street. And one was on the phone. He just open-handedly smacked her in the face, causing a bruise. And then now this month, in the 100 block of 9th Street where this female victim works, he decided to burn her calf with a lit cigarette. And he returned back to that area where she works. That's why he's violating a stay away order. So I'm asking that he does not receive standard bond, that he needs to, be evaluated, and just to protect our community. He just keeps attacking women, and it keeps increasing in appearance. As I just said, he grabs, then he's struck, and now he's burning a female with a lit cigarette. So I have concerns.
His other charges, are they pending cases?
He just has the pending case from 2021 because he was found mentally incompetent. However, obviously, if he keeps getting released, he's just going to keep attacking.
I understand. You mentioned, I think, 3 separate incidents of some type of acts of violence against women. Did any of those result in arrests in that they're pending prosecutions?
Yes, these are all pending. He does have all these open cases, and I am working with the state to bound up the charge to a felony because he does have prior convictions for battery.
All right, I'll hear from the defense.
Your Honor, again, we weren't provided police case numbers. I don't know. We're here for a misdemeanor trespass after warning. I don't know that conduct is necessarily related to this or finding a bond for today.
I can provide court case numbers if you need it, Your Honor.
You did represent that this particular trespass is from the location of a previous incident with a victim?
Correct, and Judge Figueroa issued a stay away order under B25011094. And then he returned to that location where the victim works as well.
To 1500.
And actually, just for the record, the battery was already bound up. It already has a felony case number now. It's F251007.
So if he's out on these felony cases, then what the court will then do is issue a hold for the felony division judge to address any violations of his pretrial release conditions.
So they've already been bound up, is that what I'm hearing?
That's correct, yes.
Okay.
There's now a felony battery.
Your Honor, I would ask, technically his release conditions were of a misdemeanor. He had a bond of a misdemeanor, not a felony, so I'd ask that Your Honor don't issue a felony hold and just issue a standard bond in this case.
I'm going to issue a felony hold. They can address it in the felony court. All right, Alexander SoCal.
Thank you, Judge. May I be excused?
Thank you. Thank you for your input.
Thank you. Have a great day.
Yes.
Good morning, Your Honor.
Do you have any priors?
Yes, Your Honor. Felony withhold from 2024 for felony battery. The medical care professional. Sorry.
All right, you are charged with 2 counts of battery.
Oh, and sorry, my apologies. He also has an open felony, crim miss. That is to be addressed, I think, later today.
Is that part and parcel of this case? Right,
No.
The case was already heard, Judge. The felony case, he got a bond of 1500.
Oh, thank you.
Yesterday.
I got it. And the court does find probable cause on both counts. On each count, I am going to issue $1,000 bond with a stay away order. Do we have the stay away orders?
Yes, sir.
I only have one. There should be 2.
One moment, Your Honor.
You are to stay away from Nicole Heller. And who was the second one? If you can just give me the name. Looks like Logan Floyd.
Correct, yes.
Logan Floyd, you're going to have no contact whatsoever with either of those 2 individuals. No direct contact or indirect contact. You cannot call, write, text, use social media, or attempt to communicate with either of them through a third person. Do you understand, sir? I didn't.
Yes, Your Honor.
Okay, good luck to you, sir. Just waiting on the second. Well, that nice time he's got a second one that he's spelling out for me.
Okay.
Next one is Rodney Russell.
Mr. Russell has an immigration hold, Judge.
Okay. That's it. All right, so you are charged with trespass of an unoccupied structure or conveyance.
Morning, Judge.
Good morning.
Yeah.
Court finds probable cause.
Your Honor, I don't think that there's nothing indicating that they reached out to the restaurant and asked if he had permission. And in this case, I don't think the signage is sufficient.
It was inside the building.
Well, we do have, the beat- is Miami Beach still on or they left?
Oh, well, Your Honor, I see it. There's something that says no trespassing sign was clearly displayed on the front glass of the establishment.
Yeah. All right, the court's over defense objection finds probable cause. It will be, it does have an ice hold. It'll be $500 bond. And sir, you can have to stay away if you are out from the Lincoln Road and Drexel Avenue area of Miami Beach. Specifically, it doesn't really give us, it's the 400 block of Lincoln Road. You cannot be within 500 feet of that location. Do you understand that, sir?
Yes.
All right, sir. Good luck to you. And then we have Blake Powell. Blake Powell on his way. And do we have any firms?
Yes, Your Honor. It appears he has actually open felony cannabis possession and an open felony cannabis selling near school. I think he has a prior felony cocaine withhold, a prior felony cocaine withhold, actually three in total.
Okay.
Cocaine.
All right, so Mr. Powell, you are charged with trespass on property after warning. The court finds probable cause. You are to stay away from the 800 block of Ocean Drive. You cannot be within 500 feet of that location. Do you understand that, sir?
Yes, sir.
All right, that means not now, not in the near future until this case is resolved, because you've already violated it once, and if you violate it again, it's going to be even more difficult for you to be getting out of jail.
Okay, can I, not to cut you off, can I have permission to speak, Your Honor?
I would.
Do not talk about the facts of the case, sir.
Oh, okay. Okay, no problem. All right, thank you. No problem.
I stay away order and also $1,000 bond. Good luck to you, sir.
Thank you, sir.
Placing a hold, Judge.
I'm sorry?
Placing a hold.
Hear what she said.
Are you placing a hold? The state mentioned that he had a felony case that he was out on bond on.
Let me hear. I don't know. I didn't get
Yes, that's correct. Sorry, and I can give the case number. It's F25 10326.
That's what I was trying
Okay,
to speak.
so
Tell him that I work on Bank Street, and that's why my other defender misses.
F25 10326.
326. Do you know the judge?
It has not been arraigned yet. Oh, it's it says the section 453.
Judge.
Judge Delancey. Okay, thank you. Next case is Joshua Riley.
I'm sorry, did you issue a hold or no?
Yes.
Okay, would Your Honor consider not issuing a hold? The nature of the charges as cannabis?
If he has an open case, he's got to hold. It's not for me to decide. It's for that judge to decide.
Live Street, my public defender
Okay.
misinformed me. I'm just like, please.
He's gainfully employed. He's
Mr.
concerned.
Riley, we on Mr. Riley.
Yeah.
Please not issue a hold, Your Honor.
I have to. It is another judge. You were out on that other judge's pretrial release conditions. That judge will address it. All right, Joshua Riley.
Mr. Riley has a hold for DOC, Judge.
Why is there a DOC hold? Is it you for FDOC? In other words, he's supposed to be.
Correction, since the release date is 6/3/25.
All right, so you had a bench warrant in the amount of $1,000. It'll be a $1,000 bond.
Your Honor, the warrant is from 2008. It seems like he's been in custody of corrections since then. I don't think he's trying to evade the criminal justice system. Would you consider an ROR for this warrant? I also don't know how likely it is that the state's going to prosecute a 2008 misdemeanor.
Defendant is serving a year and a day with DOC, release date June 3rd of 25. And how is he serving a year and a day if he was served this on him while he was in custody? Anybody know how this warrant was served?
You're on, sorry, did DOC try to release you and then they found out about this 2008 warrant?
No, because my release date's the 3rd.
Okay, he's in custody of DOC. He was brought here, is what I'm being told, to get the warrant taken care of. So, Your Honor, I would ask for an ROR. He's gonna, and then he can go back to DOC and finish his sentence.
That's fine with the state.
All right, well, ROR on this case. So this will just go to division. Sorry, I just want to make sure, is your address still the same? Because this is an old case. What is your address?
What's your address?
5610 Northeast 15th Avenue.
All right, 5610 Northeast 15 Avenue?
Correct.
15th Avenue.
3304, that's Fort Lauderdale, Florida.
330, what was it?
33304, 33304, sorry.
33304.
Correct.
Lauderdale, and it's a house?
Yes.
All right, so that's the new address, if the clerk can make sure they get that. All right, sir, good luck to you.
Thank you.
Then we have Justin Cinquegrana.
Let me pass him, Judge.
Pass him. Carlos Avila.
Mr. Avila. ¿Tú hablas inglés?
Yeah.
Okay. He speaks English.
Sir, you are charged with 1 count of petty theft. The court has reviewed the arrest affidavit, finds probable cause. Sir, you are to stay away from this location of 8400 Southwest 24th Street, which is the Walmart. You cannot be within 500 feet of that location. Otherwise, you will be in violation of this stay away order. Do you understand that, sir?
Yes, sir.
What kind of priors?
Several theft-related priors. I can go through them all, but more than 3 felony theft-related priors, as well as multiple misdemeanor petty theft priors as well.
Your Honor, I would be.
Since it goes back to the 80s.
Yeah, go ahead.
Your Honor, I'm going to ask for a standard bond in the alternative tap. Mr. Avila is homeless. The allegations are that he was stealing food.
All right. When was the last petty theft convictions?
So the last theft conviction was a felony grand theft conviction in 2024. Then there was a felony petty theft 2 or more convictions in 2024 as well.
There's most likely going to be
I'm
bound.
showing that's 2014. Is that right, Keaton?
Go to the last page. There's some printing towards the end.
Okay, I do see now.
There.
Yeah,
And then there's
this could very well be a petty theft with 2 or more convictions.
Correct.
Felonies. So
Correct.
I am going to elevate the bond, $1,500 bond with a stay away order. Good luck to you, sir. Brian Cortez.
Yes.
All right, Mr. Cortez, you are charged with 1 count of petty theft. Court's reviewed the arrest affidavit, makes a finding of probable cause. What kind of priors?
There was a burglary conviction in 1996. Let me check this is most recent. 2011 cannabis conviction. Most of the convictions are remote. There was a 2016 petty theft conviction. The felony convictions from 1997, including.
So nothing since 2016?
That's I just want to double check. There are some that were no action, but that's correct. The most recent conviction was 2016.
All right, I'll tell you what, I will allow pretrial services with an alternate bond of $1,500. And sir, you are to stay away from the Walmart, which is 3200 Northwest 79th Street. You cannot be within 500 feet of that location. Do you understand that, sir?
Yes, sir. Thank you.
Good luck to you.
Thank you.
John Wadley. State have an announcement on this one?
Yes, John. Yes. In case B 25-11, 327, state announces a null cross prosecutorial discretion.
So where is that written? We'll write it back here. Okay. Where? Somebody want to just let him know so he doesn't have to come up? And then the next one I have is Santos Turcios.
So it's going to be the same situation.
All right.
In case B 25-11332, state announces a null cross prosecutorial.
All right, Mr. Santos Turcios. Case has been null pros, which is dismissed. I don't know if he speaks Spanish. Spanish or
Señor, el caso suyo, ¿usted habla inglés? Oh, he
This
does.
is Mr. Wadley, correct?
well, both of them have been null pro. Tell him it's been dismissed.
Okay, your cases have been dismissed.
Been dismissed.
Yeah, you'll be released.
And then the other gentleman, Mr. Kudos, is also dismissed. And now we're on Mauri Noah.
Santos Torricos, is that who? Sorry.
That's no cross. We don't need him inside. 25, we should be on.
I think it's number 22. Okay, thank you.
Oh, they shouldn't have bonded.
I'm waiting for Mauri Noah. This is a bench warrant.
He won't be able to.
Counsel, does he need an interpreter?
He does, he needs the interpreter. He's trying to tell me something. I don't know about.
Okay, Your Honor, he has a bench warrant, is what you said?
$1,000 bench warrant.
Señor, usted tiene una orden de arresto por $2,000.
The court's going to give a $1,000 bond.
Le va a imponer la fianza en solo $1,000.
And I want to make sure that his address is still the same. What is
Señor,
it?
queremos confirmar su dirección. ¿Cuál es su dirección ahora?
Dile que soy homeless.
I want to tell you I'm homeless.
Do we need to set him for the homeless calendar?
Entonces vamos a fijarlo para un calendario para desamparados.
If Your Honor is going to ROR him, then we can give him a date certain.
Not with a bench warrant, though. I'm not going to.
Su abogado de oficio está pidiendo que lo dejen salir bajo su propia responsabilidad o palabra. Su señoría dijo que no porque usted ya tiene orden de arresto.
Okay, sir. In the meantime, you can have no contact whatsoever with the Walmart at 8400 Southwest 24th Street. You can't be within 500 feet of that location.
Señor, usted tiene orden de alejamiento, mientras tanto, del Walmart que se encuentra en el 8400 Southwest de la 24 calle. Usted tiene que estar mínimo a 500 pies de distancia de ese Walmart.
Okay.
Okay.
Thank you. Good luck, sir.
Gracias, usted se puede marchar.
Clinton.
I'm sorry, counsel, did you want him to, he was trying to tell you something and you were trying to...
Yeah, I don't know, something
Señor,
about.
¿qué es lo que usted quería decirle a su abogada?
No, que se me estaba cayendo el pantalón.
Oh, no, never mind. It's
No,
just
but-
his pants are falling down.
Entonces, ¿en qué quedó?
So, what is this resolved in?
You have $1,000, you have $1,000 bond, okay?
Usted tiene fianza de $1,000. Se puede marchar.
No lo tengo.
Ok, se puede marchar, caballero.
And then we have Clinton Zuccarini.
He's present, Your Honor.
Hello. Your Honor, I would like to plead guilty to this charge.
Your Honor.
Does the state have an announcement or no on this one?
Zuccarini? Disorderly. Yeah.
Mistake I made.
All right, so you are charged with disorderly conduct. What's the state have an offer?
Your Honor, he just took a conviction for disorderly, and we could do adjudication credit for time served.
All right, sir. Did they give the warnings to the defendants beforehand?
Did they give I'm not aware of warnings. Do you mean like a rights waiver form, Your Honor?
Normally they did, just tell them. All right, listen up, sir. You are charged with disorderly conduct. I understand that you wish to plead guilty to this charge. You would be adjudicated guilty, which is a criminal conviction on your record, and sentenced to credit for all time served. Is that your understanding?
That's my understanding, Your Honor. I would like to.
Anybody, all right, has anybody, including your lawyer, told you anything different?
Well, I haven't had an opportunity to counsel him, Your Honor.
You want to speak briefly?
Just very briefly.
Go ahead.
This
Okay. All right, Your Honor. He would like to accept the credit time served.
So I just want to make sure, has anybody else told you anything different that other than pleading guilty, adjudication, credit time served?
No, sir. I'm very happy with the service.
Listen up. Are you under the influence of any alcohol, drugs, or medication affecting your ability to understand me?
No, sir. I am
Listen up. Is anybody forcing, threatening, or coercing you to enter into this plea?
No, sir, Your Honor.
You understand if you're not a United States citizen, the entry of this plea will subject you to deportation.
Yes, sir, Your Honor. I mean,
over your constitutional rights, you had the right to have gone to a jury trial, the right to compel the attendance of witnesses on your behalf, confront and cross-examine the witnesses and evidence against you. You had the right to testify or remain silent, and your silence could not have been used against you in a jury trial, the right to appeal any mistakes that I would have made, and the right to hold the state of Florida to the burden of proving these charges beyond a reasonable doubt. Do you understand by entering into this plea that you are giving up all of these rights and we will not have a jury trial?
Yes, sir. I understand. I'm giving up all these rights and we will not have a jury trial. I am guilty.
And you had the opportunity to discuss this with your lawyer?
Yes, I have. She was very helpful.
And did you answer all of your questions?
You have any questions?
No, no, sir. Thank you, Mr. Your Honor, William.
Are you satisfied with her assistance?
Yes, sir, Your Honor. And I'm satisfied your assistance.
The court finds the defendant understands the nature of the charges against him and the consequences of this plea, that he has been represented by competent and effective assistance of counsel with whom he is satisfied. I find the defendant is knowingly, voluntarily, and intelligently waived his rights. All statutory fines, court costs, and surcharges will be assessed. Thank you, sir. Good luck.
Thank you, sir. Good luck, Your Honor. Have a blessed day, Your Honor.
You too. Thomas Jones.
You refused court, Judge. Reset.
Refused. Reset. What is that? June 1?
Yeah.
Correct.
Nicholas Braden.
Mr. Braden, you can stand here and face the judge. Yeah, Mr. Braden, Your Honor.
Braden, you were charged with trespass after warning.
Your Honor, I will be asking for an ROR in this case. The allegations are that he's homeless, that he was sleeping. His priors, although he does have priors, they are remote, and I would point out they're minimal for someone who's experiencing being unhoused.
All right, the court over defense objection does find probable cause. What do we have?
Well, Your Honor, it wasn't a PC argument, just a reduction of the bond.
Sorry?
It wasn't a PC argument. I was just asking for an ROR.
They needed to announce that I found probable cause. Go ahead.
Your Honor, we have one withhold for an RWAC from 2014, so I mean, a state would be fine with tab if the defendant's homeless.
So you only have from 2014, nothing out of state?
Well, we don't get the out of state that fast.
All right, I will place him into the TAP program, alternate bond, $1,000.
Thank you, Judge. Would you consider an ROR just because I know TAP has been takes a little while to get people out of custody.
No, but then you're never gonna see him.
We could get a date certain and he could leave with his next court date here.
No, I'd rather they process him, because if he's on a warrant, they're not gonna see him. All right, so,
500.
Mr. Nick Braden, you are to have no contact whatsoever at 1130 Fifth Street. You cannot be within 500 feet of that location. Do you understand that, sir? You understand that?
Mr. Braden, can you?
Yeah, I guess.
Okay, thank you.
Alternate 500 or 1,000, Judge.
The alternate bond was like 1,000.
Thank you.
Kenya Martin. All right, sir, you are charged with 1 count of trespass after warning and resisting an officer without violence to his person. Court finds probable cause. What kind of priors?
There's a felony withhold from 2024 for battery, law enforcement officer.
All right.
Other than that, ordinances for misdemeanors.
All right, it's going to be, I'm gonna give him the TAP program, alternate bond, $500 on each count. And the stay away order, sir, you are to have no, do you have a stay away order for me?
Writing.
Okay, you have got to be with, stay away from the 136 Collins Avenue location. You cannot be within 500 feet of that location. Do you understand that, sir?
Your Honor, the arrest form indicates he's nonverbal.
I can't hear what?
The arrest form indicates Mr. Martin is nonverbal.
Is not, well,
Could you shake your head and indicate that you understand, Mr. Martin?
sounds as though he just doesn't want to give the information. All right, well, I have no indication that he's not hearing me. So I am advising you, sir, you are to stay away from that location that I just announced, which is 136 Collins Avenue. Otherwise, you will be arrested again. Good luck to you, sir.
Judge, we have Mr. Cinco Grana that we passed. He's present now. Number 18, first name Justin.
Yes, Justin Cinquegrana.
Yes, he's here now.
Okay, does he speak English?
Not sure.
Yes. Yeah, he's right here. Hi, sir. You can stand in the box and face the judge there.
All right, sir, you are charged with petty theft. Court's review the arrest affidavit, makes a finding of probable cause. What kind of priors?
So, Your Honor, there was a 2013 felony controlled substance possession conviction, 2013 felony cocaine, 2021 felony fire obstruction. Let me see. 2018 felony controlled substance withhold. And a petty theft in 2021 as well.
All right, it'll be, I'm gonna give it TAP with an alternate bond of $1,000.
Place to live?
What's that?
Do you have a place to?
Sir,
stay?
you are to stay away from this location. You cannot be within 500 feet of the 888 Biscayne Boulevard CVS. Do you understand that?
I agree, but this isn't gonna affect me living there, is it?
Living at the CVS? Yeah, it is going to affect you living there.
Do you have a house to live at, family that you can live with?
No, I have my apartment.
You have your own apartment, Your Honor. He has an address on the arrest form. Instead of TAP, would you consider pretrial services?
Pretrial services with the felonies, I don't know. Yeah, I can do that.
Pretrial services, I know pretrial services, at least when I used to be in ERU, would accept felonies for release.
PTS, alternate bond 1,000.
I'm sorry, Your Honor, you broke up. It was PTS alternate 1,000, correct?
Next case is Travis Smith.
You're all set, sir. Oh, you can sit in the box, sir. Oh.
All right, so you're charged with 1 count of resisting an officer without violence, 1 count of trespass after warning, and 1 count of petty theft. The court finds probable cause.
Would Your Honor consider a reduced bond on count 2 of $150? The allegations of the trespass, there's no harmful conduct or activity that's alleged, and then in addition, the resisting allegation is just tensing of arms.
Several trespass conviction priors. Also, he has 1, 2, 3, 4, 5, 6, 7 open trespasses and an open disorderly conduct.
Yep. All right. As to count 1, it's $500. That's to count 2, $750. As to count 3, $750. And sir, you are to stay away from this location at 3580 Northwest 83rd Avenue in Doral, the Fresh Market. You cannot be within 500 feet of that location. Do you understand, sir?
Yes, sir.
All right, good luck to you, sir.
Okay.
John Chalaran. Oh, Halloran.
You could stand there and face the judge.
All right, Mr. O'Halloran, you're charged with 1 count of criminal mischief.
Your Honor, I'm gonna be asking for ROR on this case and the bench warrant. It's within the arrest form that the officers made no made no attempts to contact the building owner and see if he did in fact have permission. As indicated, he told him he did.
I'm an artist. I get paid for this. Made no sense.
Well, I'm going with the 4 corners of the affidavit. It may be something that he's advised the officers, but there's nothing to confirm that that is in fact the case. The court does find probable cause as to the criminal mischief, and it will be. Do you have any priors?
Your Honor, there was a felony that he completed PTI for. It was cannabis possession. Other than that, there was an RWOP that I think was associated with the felony that he also took PTI for. Other than that, he had some cannabis possession, no losses.
Going to be a $500 bond as to that count. He also has a bench warrant of $1,000 for Judge Cuervo on a DWLS. That'll be $1,000 bond. And do we have a stay order on the criminal mischief?
Your Honor, would you consider pretrial services in the alternative? Again, Mr. O'Halloran had permission to be there. The police officers made no attempts to verify that information.
You will not because of the outstanding bench warrant. But I do need a stay order. Mr. O'Halloran, you are to have no contact. You cannot be within 500 feet of the 594 Northwest 26th Street location. Do you understand that, sir?
Sorry, Your Honor. He had a question for me. I'm sorry, he didn't hear that.
Not speaking to him? Are you done? Are you?
Yes, I'm so sorry, Your Honor.
Speak. I just want to make sure you're done.
Yes, thank you, Judge.
Okay, all right, sir, you are to stay away from this location of 594 Northwest 26th Street. You cannot be within 500 feet of that location. Do you understand?
Okay, sir, I can have written permission that I'm doing work there. If I could bring that to the court.
Yeah, bring it to your next court date, okay?
Okay?
What's happening right now?
You're gonna
I'm
get
looking at the four corners of this arrest affidavit. And I need the stay away order.
Yes, John.
Justin Francis. It's. All right, Mr. Francis, you are charged with one count of resisting an officer without violence to his person. And there's also a bench warrant under case number AIC PLCE. We'll handle that one first. On that one, it will be a $500 bond.
Your Honor, I know that you typically don't offer pretrial services or ROR when there's bench warrants, but would you consider for Mr. Francis, the warrant is from 2 days ago, from May 28th?
Not at this time, because I also have to deal with the resisting an officer without violence, which quite frankly, the four corners of this affidavit show it fleeing, which is a third-degree felony, but certainly there is a probable cause for the resisting without. What is his history?
Your Honor, there was only a felony full cross, so technically no priors. But that's an assault with the death weapon.
Someone just worked and the officer came to the scene.
Going to issue a $1,500 bond.
When I was detained, I just left and I knew I was legally liable. Just
That's an argument your lawyer might be able to make during a trial. You can call the public defender's office if you're not able to pay your bond to try to get an ROR through a different judge, okay?
Cortez. Carlos Cortez? Is this you?
Your Honor, this is still Mr. Francis. You're all set.
15 and 5 or 5 and 5.
This case for Mr. Cortez, Judge, was added yesterday. He also is a fugitive from Lee County.
Okay.
Buenos días, señor. ¿Usted habla inglés?
No.
All right, you are charged with driving with a suspended license, and there is also a bench warrant that was issued on a driving with license suspended, as well as a $1,500 bench warrant for no valid driver's license. On the no valid driver's license, it'll be $1,500 bond.
And Your Honor, I didn't get the county that corrections said before. I forgot what correct.
It was Lee County, I believe.
Lee County, thank you. Ok, señor, usted se le acusó de estar manejando con una licencia suspendida, pero además tiene una orden de arresto del condado de Lee, y esa incluye una por manejar con licencia suspendida, otra por no tener licencia válida. Le están emitiendo una fianza de $1,500 por la licencia suspendida, $1,500 por no tener licencia válida y...
All right, so for no valid driver's license, it'll be a $1,500 bond.
I'm sorry, Your Honor, I don't have those. I don't have anything in the arrest affidavit indicating a bench warrant, and his priors are printing blank for me. So can you give me the case number?
Judge, he's only here for one case, the bench warrant, which is AJU 1QOE.
All right, well, that's what I have. Okay, that was what I just said. That's 1,500. Bring up these other ones.
Ok, y está indicando que solo es la orden de arresto del condado de Lee los que tenemos aquí.
There is a fugitive warning for this dependent as well.
Pero esto es una orden fugitiva.
All right, they have it on the calendar, this case as well, which is for the driving with license suspended.
The bond was given yesterday. He was RR on that case.
La fianza que usted tenía de ayer lo dejaron salir bajo su propia responsabilidad o palabra, que era por manejar con licencia suspendida, pero eso era de aquí.
Then we go to driving with a suspended license, which is case number. Well, what is the case number? It's going to be just a police case. Number.
8LH.
That's the same thing. Wait a minute, that's the DWLS. That doesn't make sense.
I believe the correction said it was addressed yesterday.
The case ended in SE. He was RR yesterday, Judge.
El caso viejo de ayer, ustedes lo dejaron salir bajo su propia responsabilidad o palabra.
Oh, I see.
That's what she's saying, it was addressed yesterday, Judge.
So then we're done.
Okay.
All right.
Bueno, ya, con eso concluye. Se puede marchar, señor.
All right, it was already addressed.
Your Honor, so the bench warrant, it's $1,500.
Whatever it was, I didn't. Yeah.
1,500 was the.
15.
Would your Honor consider reducing it in because of the nature of the charge?
No, I am not. I read
Su
the.
señoría rehúsa reducir la fianza. Su abogado de oficio está pidiendo que se la reduzca. Se va a tener que pagar ambas fianzas. Se puede marchar, señor.
There's nothing in the arrest form indicating that he had an open bench warrant for that case.
Pero no hay nada en la orden de arresto que indicara que él tuviese una fianza o una orden de arresto previa.
Do you see it in the system? Can somebody confirm?
¿Hay alguien que lo vea en el sistema? Por favor, confírmenlo.
Added yesterday, Judge. It popped up yesterday. It was added to the jail card. That's why he's here today to be addressed.
Porque salió ayer y por eso lo volvemos a traer hoy.
All right, we go to Joshua Escobar.
Se puede marchar, señor. Viene otra persona. Se puede marchar, señor.
¿Cuánto es la fianza?
Yo hablo muy poquito español. Your bond is $1,500 on the bench warrant, okay?
Una de las órdenes de arresto fue 1,500, señor.
Fine.
Judge, you have one case before you.
I have right now Joshua Escobar.
You have the case ending in R8LE.
I have an HOPJE. Yeah, R8LE. I have that one as well.
Okay. You only have that one case before you, the 8LE.
Was that the same situation from yesterday? Because it was two printed on the calendar.
Let's see 2 cases.
The case ended in PJE. He was given free trial alternate $1 yesterday by Judge Glazer.
All right, on the bench warrant for $500, it's going to be a bond of $500.
And Your Honor, there is the open felony, or I guess that's the current case, either that was addressed yesterday or is supposed to be addressed
It
today.
was addressed yesterday. He got free trial alternate $5,000 on the felony.
5,000. Thank you.
Your Honor, are we here on the failure to obey then? Or you said that was addressed yesterday as well, and we're just here on the bench warrant? I'm sorry, corrections.
The only thing that I addressed was the bench warrant.
Okay, all right.
Correct.
Go to the next one, Demetrius Deshawn. We are running behind, folks.
And this is just on the bench warrant.
Yep. All right, is Demetrius Deshawn.
He was reset NBC, Judge. Reset for tomorrow.
It's NBC reset 6-1. Tercer Carlos or Carlos Tercer Eagland. This Mr. Carlos Tercer Aikland? Yes?
Yes, Your Honor.
Okay. All right, there's a bench warrant under 8JLRDYE for $1,000. It will be a $1,000 bond. And I have another matter before me under case number AJLRDZE. $1,000 bench warrant. I'll lower that to $500 bond.
Thank you, Judge. Would you consider lowering the the first bench warrant as well to $500?
That was the
He's living out of state, so he won't be eligible.
500 as well.
Thank you, Judge.
Let's go to the next one. Robert Seuss or Susie. Susse. Is this Robert Susse?
You want Mr. Susse?
Yes. All right, sir, you are charged with reckless driving.
That's correct.
All right, going to be, court does find probable cause.
Your Honor, his priors are printing blank for me. I'd be asking for a bond of $500.
That's correct. And that's fine with the state.
All right, $500 bond. I was close to elevating that, sir. These are very serious allegations. God forbid there were any children in the area while you were allegedly recklessly driving. Good luck to you, sir.
Thank you, Your Honor.
Your Honor, if I may.
Yes.
This is going to be our client. We were just retained. Would you like for me to file pleadings today, right now, or Monday morning?
Yeah, I don't even know who's speaking. I'm not
It's
seeing.
Isabella with the law office of Orlando Rodriguez. I don't know why my camera won't turn on.
Okay, yeah, so go ahead and enter your appearance.
Okay,
I don't know where it's going to go, but.
that's fine. Okay, perfect. Thank you so much.
Thank you. So public is discharged on this matter if you.
Yes.
Notice of appearance has been filed. Thank you, ma'am.
Thank you.
And we go to Devin Alberto.
He's going to be on your barn here. We calendar the next.
But we can handle these for right now.
Correct, Judge.
All right, Mr. Alberto Devin, there is a warrant for $150 for DWLS. I'll set bond at $150. The new case, well, we do have a DUI and a second or subsequent refusal, as well as driving with a suspended license. Reviewing the arrest affidavit. Court finds probable cause. Where am I? What did I write it on this one? Oh, I see. It's got the several figures. As to the driving under the influence, it will be $1,000. On the refusal, $150. And on the driving with license suspended bench warrant, it'll be a $500 bond. It was a $500 bench. Okay, thank you. Terrence Sutton. Mr. Sutton, you're charged with possession of cocaine and driving with a suspended license.
So, Your Honor, I know he's gonna see you for the felony charge. He has no priors that I see. I would just ask for a $1 bond on the misdemeanor.
I don't see any local cars as well. Let's see. Say we just be asking for standard bond from DWS, which I believe Your Honor's been setting at $500.
Well, I'll give it $150 for the driving with suspended license. If I didn't mention it, court does find probable cause. See on the bond hearing then for the felony. We'll go to Arcelia Lubin.
Similar situation there with this felony.
Charged, is it Arcelia Lubin here? All right, Arcelia Lubin, you're charged with what kind of brand theft of a vehicle and no valid driver's license. Court has reviewed the arrest affidavit. Finds probable cause.
Your Honor, I would make the same argument as I did for Mr. Sutton. He has the felony he's gonna see you for, so I'd ask for a $1 bond.
All right, bond will be set for the LHOWHE at 150. Daryl Camacho Fernandez. All right, this Daryl Camacho Fernandez.
Similar situation here.
Yep. All right, you have a charge with driving without a motorcycle endorsement on your license.
He requires a Spanish interpreter.
All right, so you're charged with, for right now in the misdemeanor court, you're charged with driver's license, failure to have a motorcycle endorsement on your driver's license. Do we have the interpreter?
Yes, Your Honor. No motorcycle endorsement, I'm sorry.
Charged with no motorcycle endorsement, yes.
Señor, se le acusa de estar manejando una motocicleta sin tener endoso de motocicleta en su licencia.
The court has reviewed the arrest affidavit.
Su señoría acaba de repasar el informe de arresto, la atestación de arresto.
And finds probable cause. Bond will be set at $150.
Su señoría ha determinado que hay motivo fundado ante dicha acusación, fianza de $150.
We will see you in the bond hearing shortly on your felony charge.
Brevemente lo veremos en la vista de fianzas por delitos mayores dentro de breve. Usted se puede marchar.
And then we have Goran Perez Unieski.
Se puede marchar.
Okay.
Okay.
One moment, Your Honor, they're getting Mr. Gorin. Hi, Mr. Gorin. Do you speak English?
No.
Okay. Mr. Gorin needs a Spanish interpreter.
All right, sir, you have a bench warrant for driving with a suspended license of $3,000.
Señor, usted tiene una orden de arresto por estar manejando con una licencia suspendida. La fianza es de $3,000.
I will reduce the bond to $1,500.
Su señoría se la va a reducir a solo $1,500.
You also have a bench warrant for driving with suspended license for $150.
También tiene otra fianza por estar manejando con licencia, orden de arresto por estar manejando con licencia suspendida. Esa es por $1,500.
As well, bond.
Esa te van a imponer esa fianza inclusive.
And I think that's.
Y creo que esa es la última.
A new case.
Pero él tiene un caso nuevo, señoría.
There's a new case of driving with a suspended license.
Y tiene otro caso nuevo ahora por manejar con licencia suspendida.
Arrest affidavit.
I don't have an arrest
Su
affidavit. for
señoría
driving.
está repasando el informe de arresto. Su abogado dice que ella no tiene el informe de arresto.
Does anybody in the jail have an arrest affidavit?
So the bench warrant, the bench warrant was 15.
Correct. Well, there's two. You have $1,500 and is okay, so the new case is the ALHOW 7E?
Yes.
Okay.
Ahora ya ve, su señoría, el caso nuevo que usted tiene ya fue confirmado por los carceleros. I'm sorry, Your Honor.
Court finds probable cause.
Este tribunal ha determinado que hay motivo fundado ante dicha acusación.
And the bond is going to be $500.
Y en esa la fianza son $500.
All right, thank you.
15 for the bench
Gracias.
warrant.
Say it again.
The bench warrant case is 1,500.
Bench warrant was, it was originally a bench warrant of $3,000. I gave him a bond of $1,500.
Thank you.
Okay. Los carceleros estaban confirmando que su señoría en uno de los órdenes de arresto te redujo la fianza de 3,000 a solo 1,500. Usted puede marchar, por favor.
Okay. Thank you. Thank you.
Okay.
Are these bonnets?
Sorry, who is this? What's your name?
Marvin.
You know what number on the calendar he is? 50.
Is there an hold?
Do you speak English or do you need an interpreter?
¿Necesita intérprete o hablas inglés?
He needs the interpreter.
Okay, do we have an ICE hold on this defendant? It looks as though there should be.
Usted también parece que tiene una orden de retención de parte del Departamento de Inmigración.
No, eso fue.
No. This is
No,
for
that was later or before. I couldn't hear what he said.
It's okay. Just I'm gonna ask him that he doesn't say anything on the record. It could be used against him. We're just trying to get him a bond today.
Su abogado de oficio, la joven que está aquí, ahí a su izquierda, el abogado, ella le está pidiendo a usted que no siga hablando, que lo único que quieren es ver cómo le pueden conceder, buscar una fianza hoy.
No entiendo.
I understood.
You're not on the jail card, Judge.
All right, because it's in the A form that is, there was a failure to appear unlawfully present due to order of removal. So, all right.
El informe de arresto indica que usted nunca se presentó a la orden donde lo iban a deportar.
All right, you are charged with no valid driver's license.
Usted se le acusa de no tener una licencia válida.
Court finds probable cause.
Este tribunal ha determinado que hay motivo fundado ante dicha acusación.
Bond will be set at $500.
Fianza $500.
Good luck to you, sir.
Buena suerte, caballero. Se puede marchar.
Gracias.
Thank you.
Then Jose Vasquez.
He's coming, Your Honor.
All right,
Mr. Vasquez needs a Spanish interpreter.
You are charged with not having a valid driver's license.
Señor Vázquez, usted se le acusa de no tener licencia válida.
I find probable cause.
Su señoría ha determinado que hay motivo fundado ante dicha acusación en contra suya.
$500 bond.
$500 de fianza. Se puede marchar.
All right, good luck.
Buena suerte.
Okay.
Okay.
Thank you.
Judge, excuse me, Judge.
Yes, ma'am.
I have a discrepancy on page 2, number 5, the female Coronado. On the case ending in 2367.
Usted se puede marchar, señor. Eso no es con usted. Señor, usted se puede marchar. Eso no es con usted.
We have 1,500 for that case, but in the CJS it has 500.
It should be 500 for the drug paraphernalia, 1,500 for the trespass.
1 second. Okay, so what's the issue?
We have 1,500 for that case, but I was told you wrote 500.
I think originally I had put 1,500 and I reduced it to 500.
Because the standard was 3,000 and you reduced it to 1,500. So you changed it again to 500?
Wait, there was a reason. Hold on. Anybody recall why I reduced it from 1,500 to 500? Madam Public Defender, she's not, I don't know if you were.
Your Honor, I don't believe you reduced it.
I'm here, Judge. My notes indicate that you kept it standard bond of $500 for count 1 and $1,500 for count 2.
There's 2 different cases.
Correct.
The bench warrant we're addressing.
Okay, my notes indicate $1,500. That's all I have.
They are separate cases. The other case was the trespass, which was for the bench warrant for the trespass.
Okay, but that's.
500. And then on that one, 500.
Okay, so there is a discrepancy. All right. So for the new case, which is the drug paraphernalia, that's 500.
Right.
The bench warrant is 1,500.
Correct.
Okay, so,
Thank you.
all right. Yeah. That's what happened. Okay, thank you for catching that.
Thank you, Judge.
Okay. All right, how much time do we need for the felonies?
I will go get the APD who's doing felony bonds now.
Your Honor, this is Joanne Hennessy for the City of Miami Beach. I'm here just for the jail arraignment calendar, if I could be excused.
Okay, yes. You may.
Thank you.
Thank you.
Thank you, Judge.
All right, thank you. It was a pleasure.
Can we get 10 minutes, Judge?
You can take 20 minutes. All right, I'm debating what I should do. Stretch. You said in the plural?
Yes.
You said plural? Really?
Judge, are the bond hearing, the felony bond hearings next?
They're supposed to be, yep, probably in about 10 or 15 minutes. I'm debating whether I should go up. Wow.
Breaking me my hand on because
wow. There's okay. Look at that. That is amazing. Yeah.
Good morning, Judge Opfield. This is Laura Adams. Can you hear me?
Yes, I can. Good morning.
Good morning, Judge Outfield. This is Laura Adams. Can you hear me?
I can hear you. Can you hear me?
Yes, sir. Thank you.
We're just waiting for them to switch gears and get ready. I'm gonna walk off the bench just to stretch for a little bit, but we should be starting in about 5 to 10 minutes.
Thank you, Judge.
Thank you. Yep. Sure. Yeah, if you can avoid, yeah, that's fine, as long as we don't have that issue again. If need be, we can always just go onto my Zoom ID to complete the afternoon calendar. All right.
Your Honor, do you want me to go to 6-2 or stay here in the meantime?
No, just stay right here for now. That was for 1:30 for now.
Okay, all right.
And that's considered, what is that? Is that? It's good. Decent. Average, okay. Happy good birthday.
I'll be right back. I'm gonna go upstairs to borrow one just to get things out again. Since we have access.
There is what he did? Yeah, okay.
Okay, yeah, or I can get the other one, yeah. That's what we've been.
Who's gonna start felonies?
After
it.
that for you, you done?
Not yet.
I'm hungry. You were. Late in the day, I didn't realize how hungry I was. Like really. They better go back on. I can make this one. This is the only judge that actually worked for myself and both. My older brother's been retired for what now, 15 years?
What nothing? It's one of these. Did you take my hand? Oh, why would you? It's the two of them, one highlighted.
You spinning it around.
Your time. I didn't.
All right.
Want to start giving me A forms, I can take a look at them.
Yeah, so yeah, I'll give the calendar, and this was the lady that was waiting, Bobby.
Okay,
Number 12 on the calendar on page 4.
okay. And then, did you get the other attorneys who had,
You don't.
okay. Mr. Matheny, what's the name of your client? We'll start with that one.
Appreciate it, Your Honor. Good morning. I have Jillian Bentley, Eric Matheny on her behalf. My co-counsel Francesca Sarmiento is also on.
Page one. All right. Was there anybody else who wanted something taken out of turn?
I think Lauren too. I saw her there.
Yes, she was on. Yep.
Yes, Judge, my client is Ivana Gomez, F 11031.
Okay. Anybody else? If not, we're just still waiting. I just want to make sure we get it pulled out.
I didn't know it was there.
Good news, Judge.
Yes, ma'am.
Robert fixed everything upstairs.
Oh, good. So we'll be good to go for tomorrow? Or we're good to go for this afternoon? Okay, with this afternoon and tomorrow also. Okay.
Some but I guess revert some settings that are it's just that up to make it easier for the operators.
All right. So as long as it's fixed, we're in good shape. Thank you. Okay.
I said, what? I'm ready to begin.
Okay.
I'll call you, please. Oh, other than that, you're done. There. Why aren't they AP?
This is like what? You know, before my birth. Huh? So they, well, give it to us and. Okay. I'll be spinning around like Tasmanian devil.
Yeah.
Wait, what happened? What? I missed.
We're talking about Good Friday. This is a good experience.
Okay.
I just know.
Friday was here till 10 o'clock.
What do you mean 10 o'clock?
And
Are you serious?
I was there that, but I was there a couple months ago. We were there until 7:30, 8 o'clock.
yeah,
Why?
actually.
The same number of days.
The judge did finish the morning juvenile session until after 12.
Oh, this?
Number 42. We can do them after the female. Yeah. Because these figures are so morning. Okay, thank you. Number. We have Oh, sorry, not number 3 and not number 2. Well, 3 and 4. I mean, it's 3 and 4. We need to take another turn. When the first and then okay, got it. Got it. It's gonna go first, then we'll do number 12 and different.
Women on page 1 and the one that's in.
Oh, wait, the women first and then the out of turns? Okay. It's what? 2 of these are women, okay. So it's just one more?
No,
I'll get
2 more.
Few more, okay.
maybe it was ladies. This will be afterwards. Yeah. Gomez. Then back.
Yeah. With the red name.
What's it? 45, I think that was. Devin, the one you told me to get him to take him out of turn? Oh, I just took him out of turn. You don't wanna wait? You wanna wait? You're gonna be one of the first ones now, not the first one, but right after the female, okay?
I'm ready.
All rise and please raise your right hand.
Todos de pie, levanten sus manos derechas.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Say I do.
Jura o afirma que el testimonio que ustedes van a rendir será la verdad y únicamente la verdad. Si acaso es cierto, por favor digan que sí.
Try it again. Get it?
You sit down, everybody else stand up.
Try it again.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Say I do.
Juran solemnemente que el testimonio que darán será la verdad y únicamente la verdad. Por favor digan que sí, si es cierto.
Thank you. Please be seated.
Gracias. Por favor, tomen asiento.
Okay, good afternoon, folks. This is the felony bond calendar. We will start with the female calendar and then take those out of turn for private counsel. We start with Alejandra Quintero. Is that you, ma'am?
Yes, sir. And good afternoon, judges. This is Assistant Public
Sure.
Defender Natalie Temmie for the record.
Okay, thank you. Public defender will be appointed on all cases unless otherwise noted.
Accepting appointment.
A probable cause determination as to the possession of cocaine. The court has reviewed the arrest affidavit and possession of drug paraphernalia and finds probable cause. There is also case number F25-11052, failing to redeliver a hired vehicle. Court has also found probable cause. Where do you want the right to PC? Here. Okay. Perfect.
I'm sorry, public defender. This is the clerk. Can you announce your name for the record, please?
Yes, this is Assistant Public Defender Natalie Temmie for the record. Can you hear me?
Yes, thank you so much.
Thank you. And we're accepting appointment on all the cases as defined by Judge Altfield.
All right, as to count one for the possession of cocaine is 2,500. Count two is 500. And then we go to the failing to redeliver. $2,500 on that count.
Judge, can we ask for an alternate of house arrest roaming in the event that you cannot pay this bond?
What kind of priors does she have?
I don't see that she has any prior felony convictions, prior arrests, and a withhold to a petty theft misdemeanor.
Your Honor, we do have a copy of the national priors here as well, though. There is a Nevada possession of a controlled substances felony from 2022. I don't see the disposition of it, however.
Yeah, I'm going to go ahead and leave the bonds as stated. We go to the next one, Andrea Roa.
Your Honor, if we can pass her, she's not here yet.
Okay, I'm going to give it to you or just put it on the side. And Lillian Bentley.
We can pass her, Your Honor, she's not here yet.
Jillian Bentley,
Yeah, that was yours. Yeah.
is she not here?
She's not here yet. They went to pick her up.
Okay, we'll pass that one as well. Next matter is Ivana Gomez.
Good morning, Your Honor.
If we can pass her, Your Honor.
Why? Why are we passing her?
Nobody told us to do the female calendar first, and we don't have any bodies here.
And you're right, when that case is recalled, that's the one that Ms. Laura Adams wanted to address.
Understood.
Thank you.
All right, well, then let's continue. Jakaya Harris.
If we can pass her, Your Honor, she's not here yet. They went to pick up the females.
Alrighty, then that was a just kidding moment.
We have Denise Suarez, Your Honor.
And Denise Suarez. And okay, these are all females. Okay, let's.
Here's the males.
You put the.
You said you do have Flores? Okay.
Judge, I do have a probable
Denise
cause argument.
Suarez.
Suarez or Flores? I think it's Suarez, Your Honor.
Suárez, Denise Suárez.
Miss Suarez, ¿usted habla inglés? Do you speak
Yes.
English?
She speaks English.
Okay.
All right, Ms. Suarez, you are charged with possession of cocaine and possession with paraphernalia with intent to use.
Judge, I have a probable cause argument if you would hear it.
Go ahead.
I'm asking that Ms. Suarez be released under own recognizance on this arrest. Pursuant to the four corners of the arrest affidavit, the driver's side is the area that had alleged narcotics that were tested, not the passenger side. Ms. Suarez was the passenger at that time, and there were no narcotics found on her.
Yeah.
Neither was the pipe found on her. So all the tested and actual evidence of narcotics are attributable to the driver's side, there was a driver. I think we just had the co-defendant up here a minute ago.
Your Honor, may I?
Yeah.
Sentence, one of the paragraphs on page 2 of the arrest
What
affidavit.
paragraph?
Let me see, 1, 2, 4, 5. The 5th paragraph, Detective Mullet instructed the passenger to exit the vehicle. On her exit, he observed another crack pipe in plain view on the passenger seat.
But there's nothing in the arrest affidavit that says that crack pipe had any residue in it.
Exactly.
Court does find probable cause. What do you have? You have,
Yes, we have,
cocaine.
let's see, that's correct.
Can you take pretrial services? Yeah, all right, let's do pretrials. They have been homeless.
Yes.
She's listed as homeless, Judge. Can she have TAP or pretrial services if she does find
Yeah.
an address to stay at?
Yeah.
Misdemeanor. You don't do homeless.
The homeless conference is called that. Checking with the date.
Yeah, okay.
Will be 6:30.
All right, so why don't we, let's give her tap.
Okay.
With an alternate bond of 2,500 and 500. Yeah. Okay, then we go to Rosa Maria Barillas. These were, you don't have these or you do? You have Rosa Barillas. Corrections. Do you have Rosa Barillas?
It's here, Your Honor, coming up.
Thank you.
Just here. Yes. Your Honor, state had stay away orders and a motion for pretrial detention in this case. Thank you.
And defense has a probable cause argument, Judge.
Buenas tardes, señora Rosa. ¿Usted habla inglés?
All right.
She speaks English.
Okay.
You are charged with first-degree arson as well as attempted felony murder, 5 counts, and resisting an officer without violence to his person. I'm reviewing the arrest affidavit. All right, you said you had a probable cause argument. Go ahead.
Yes, Judge. So with respect to the first-degree arson, under the statute, there would have to have been no lawful purpose for her to have lit a flame or that she was in the commission of another felony. I don't see anywhere in the 4 corners of the arrest affidavit that she had no lawful purpose. In fact, it says that, whether there were other options, Ms. Barillas lit a match because she was trying to find her way in the efficiency space that she was living in. From everything that she said and the evidence, it looks like it was an accident that she immediately tried to put out the fire once she lit the match and it fell onto bedding. She herself sustained injuries. She herself went to the other areas or residences in that location and was banging on the door, trying to alert the alleged victims that a fire was occurring. At no point does she say that she, had ill intent or was just lighting it for fun. In fact, it's that she, while there was electricity, still she states that that was what she had chosen to do. She was lighting a match, trying to see. And that I also think that there are clear mental health concerns where she's described, as
Your Honor.
elderly and incoherent at some points, or the detective himself opined that she could be suffering some sort of mental health crisis. So I don't find any intent or unlawful purpose or commission of a felony that would support probable cause to arrest her for first-degree arson or attempted felony murder.
State.
Okay, thank you, Your Honor. On the 6th page of the arrest affidavit, the officer notes there was evidence of accelerant being used to intensify the fire, which is not consistent with the defendant's supposed notion of why the fire was lit in the first place. Furthermore, the defendant stated she was mad. The arguments that were made don't seem to be as much probable cause arguments as they may be arguments for trial or some later motion.
Yeah, court at this point, based upon the four corners of this affidavit, finds probable cause on all of these counts. I need to, for the arson, well, the state having filed a motion for pretrial detention. Let me take a look at this.
Yes, Your Honor. Arson is one of the enumerated statutes.
Just my only last remark would be, as far as the accelerant, it's not indicated what exactly that was, if it was something that was flammable or part of, there were matches that she was clearly smoking, if she was smoking any item or anything like that.
I don't smoke.
Okay, so, or that she herself intentionally had used that accelerant, or that there was accelerant on her.
To take my pain,
No bond status. As to count 2, no bond. Actually, it goes all the way through count 6, I believe, because you have 5 counts.
1 through 6, no bond, Your Honor?
For right now, yeah, I got to go through the entire bond. And then count 7, resisting without violence, will be 500. And there should be a stay away order, many stay away orders. Miss Barrias, you are to have no contact whatsoever, no direct contact or indirect contact with any of the following individuals: Angela Moss, Roxana Fernandez,
I don't know those people.
listen up, Arlenis Vasquez del Frade, Carlos Castellanos Verges, Carlos Couto. You can have no direct contact or indirect contact with any of these individuals. You cannot call, you cannot write, you cannot text, use social media, or attempt to communicate through a third person with any of these individuals. Do you understand that, ma'am?
Yes, I do not have a computer somehow.
Okay, did you hear me? Did you understand that?
Yes, I did.
Okay, thank you.
And you're granting the motion, Your Honor, for pretrial detention?
Detention at this juncture, yes. All right, the next case that I have is Princess Ellis.
Miss Ellis is a fugitive from Georgia with no bond.
All right. All right, Miss Ellis, you are charged with escape and resisting without violence. Reviewing the arrest affidavit. Court finds probable cause on count one, $15,000.
I'm sorry, Your Honor, which case?
Well, for the escape charge, F25-11058. You have another case?
Yes,
wait,
yes, two cases.
that in a second. I'm dealing with the escape and resisting without, and as to the resisting without, it's $1,000. On the second case, which is F25-11057, court's reviewing the arrest affidavit. Court finds probable cause. My only issue is the amount on the grand theft. Okay, here we go. The victim is so lost in excess of 100,000. All right, court does find probable cause on all counts. As to count one, it will be $5,000. Count two, $5,000. Count three, $15,000. And count four, $5,000.
Judge, with respect to count two on the first case for resisting without violence, the misdemeanor, would you consider changing that from 1,000 to 500 to just 500?
I don't have a problem with that. We'll make that 500 then onto the original case. Count two, F25-11058. Count two will now be $500.
And I wouldn't know that she has a fugitive warrant hold.
All right, fugitive hold as well. Next case I have is Jane Doe. Oh, okay, hold on one second. There is a stay away order, ma'am. Miss Princess, Ellis, you are to have no contact whatsoever with Heather. It's a location. Yeah, should have two. I have a location here. And then I have okay. There are two stay away orders that I'm going to be instituting. You cannot be within 500 feet of the, was it a Nordstrom's? The Nordstrom store located at 19507 Biscayne Boulevard in Aventura, Florida. In addition to that, you have a stay away order. You can have no contact whatsoever with Heather Rawlings, no direct or indirect contact. You cannot call, you cannot write, you cannot text, or you cannot use social media to communicate with Heather Rawlings. Do you understand, ma'am?
Yes, Your Honor.
All right, good luck to you. Jane.
Miss Jane Doe refused court. Reset for tomorrow.
Okay. Okay, perfect. Yep.
Your Honor, we have all the females that we passed.
Got it. All right, well, I do have Catherine Dean as my next one. Is that who you got? Is it Catherine Dean?
Yes.
All right, you're charged with petty theft, 2 or more convictions.
You have two cases, Your Honor.
I do. Thank you for letting me know.
She's a fugitive from Seminole County. She has no bond.
I'd ask that she has a dollar bond for the petty theft charges, given that she's held no bond with a fugitive warrant.
And you are also charged with another case of petty theft, 2 or more convictions. I'm reviewing the arrest affidavit on the 11027.
And as to that case, Judge, I do have a probable cause argument.
Go ahead.
Judge, with respect to the case ending in 11027, within the 4 corners of the arrest affidavit,
Speak up a little louder.
My apologies. Within the 4 corners of the arrest affidavit, it doesn't indicate who between the co-defendants took the merchandise, who had the merchandise, who was collecting it, and actually had it on them and was selecting those items. It's unclear. For those reasons, I'm asking that you really trying to recognizance for that case. She also wants the court to know that she is 5 months pregnant and it is a high-risk pregnancy.
Taking charges, he did it, you know, I was just.
All right, the court still finds probable cause. I do see that they both were gathering as co-defendants the merchandise, passing all points of sale. And I'm now looking at the other case, 11042, petty theft, 2 or more convictions. Apparently allegedly occurred the day before. Reviewing the arrest affidavit. Also find probable cause on those counts as well. On the 11027, it will be $5,000. On the 11042, it will be $5,000. We should have stay away orders.
Yes.
You are to have no contact, ma'am, with the what is it, Walmart located at 21151 South Dixie Highway. You cannot be within 500 feet of that location. Do you understand that, ma'am? Do you understand that? I didn't hear.
Yes, sir.
Okay.
And
there is a fugitive holdout of Seminole.
And there's another stay away order for the other location.
Well, I thought they were both the same location.
No, 1133501.
33501 South Dixie Highway as well, man. That Walmart as well. Do you understand that? You cannot be 500 feet of that location.
Yes, sir.
Okay, thank you. Yep, the females are here. Kaya Harris. Okay.
Kaya Harris. She's there.
We have Ms. Harris present, Judge.
Okay, Miss Harris, you are charged with aggravated battery of a pregnant victim. The court has reviewed the arrest affidavit, makes a finding of probable cause.
Judge, you have a probable cause argument with respect to that. As far as the aggravated battery, I'm asking that you do not find that it was aggravated. There's no indication within the 4 corners of the arrest affidavit that there was great bodily harm caused to the alleged victim, or that she had any permanent disfigurement or permanent disability.
What
While
about
the pregnancy is an aggravator, but there also has to be the second part found, which is some sort of great bodily harm, permanent disability, or permanent disfigurement. That was from my reading of the statute.
All right, state.
One moment, Your Honor. My initial understanding was that it was aggravated due to the fact that the victim was pregnant, but reviewing the statute now. Okay, so
Why do they not have a statute?
Your Honor, okay, so per the statute, aggravated battery 784.045 subsection, let me see, this is 1B. Yes, a person commits aggravated battery if the person who was the victim of the battery was pregnant at the time of the offense and the offender knew or should have known that the victim was present. Here we have victims told the subject that they're 7 weeks pregnant. So that the fact that the victim was pregnant was the aggravator itself.
So the court does find probable cause as to the aggravated battery. It will be $7,500. And
Ms. Harris has no priors that I'm seeing. Would you consider also giving her pretrial services in the alternate?
No, not with these allegations. What, do we have any history with that?
Let me see.
And I want to say that 7 weeks, the earliest usually a woman can determine her pregnancy is at 6 weeks. So she may not have been showing. That's not actually been verified.
No local priors and the NCIC are clean as well.
All right, it'll be $7,500 with a stay away order. Ma'am, you are to have no contact whatsoever with Sukanya Reagan. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate through a third person. Do you understand, ma'am?
Yes.
All right, good luck to you. All right, I think we're now ready. Was it Jillian Bentley?
Yes, Your Honor. Good afternoon now. Eric Matheny on behalf of Ms. Bentley and my co-counsel Francesca Sarmiento is present as well.
All right, the defendant, you want to wait for the defendant to be brought?
Jillian Bentley. Okay, this is Miss Bentley, Judge.
Thank you. Ms. Bentley, don't say anything. Your attorneys are here.
Okay, the defendant is charged with custody interference by a parent. The court has reviewed the arrest affidavit, does make a probable cause determination. I'll hear from both sides.
Your Honor, I just want to make the court aware that Ms. Bentley has no priors, that she is the victim of domestic violence. That's case M25-9345, State versus Jason Hanselman. State filed an information in that case on May 27th. By leaving with the children, she was a victim of domestic violence, and the statute actually carves out an exception. Defendant was the victim of an act of domestic violence, had reasonable cause to believe that she was about to become a victim, and that the escape was necessary to protect and preserve the minor from exposure to domestic violence. Ms. Sarmiento, who's my co-counsel, she's handling the family side as well, has already filed a petition for paternity.
Counsel, question. Did she at any time advise the officer of her intention to leave because she was fearing for the child's safety?
I'm without knowledge of that. I'm simply advising the court of what I consider to be strong mitigating factors in support of reduction of this bond.
All right, go ahead.
Okay, so furthermore, what I was stating is that there's already a petition for injunction that's been filed. There's already a petition for paternity, a determination of paternity has been filed. And like I said, she is the victim of domestic violence in that case. She has no prior history and was just trying to get away from a very violent situation.
If private counsel would allow me to assist as a friend of the court, I have one remark, but otherwise I'll stay in my lane.
What's the remark?
My understanding of custody interference is that she would have had to have been preventing someone that had lawful custody rights from accessing their children. And under the arrest affidavit, Miss Bentley had 100% custody that was granted. The alleged victim did not have custody. The charge is not, violating a court order. It's interfering with somebody's custody.
That's correct. There was no court order in place. They were an unmarried couple.
And it says that she had 100% custody at the time that she had her children, not the alleged victim in this allegation.
All right, I'll hear from the state. Anything further from defense?
No, Your Honor.
So, Your Honor, I'm not sure if that was a probable cause argument. But as far as priors go, the defendant has no priors. We'd be fine with PTS in this case. With ultimate bonds of $2,500.
My options, counsel, because there may be a valid argument as it relates to probable cause. If that's the case, I can have a probable cause hearing tomorrow, or otherwise, if you want to stipulate and we can talk about some type of form of release.
I would rather, for purposes of getting her out of here, I would rather stipulate. My only issue with pretrial is her living situation. She had to escape a violent living situation, so she really has nowhere to stay right now other than a friend in Homestead. So I would ask, can we do just, would the court be comfortable with $1,000 per count?
I need a GPS.
That could, Your Honor, that could be, her living, so the court pretrial services with the GPS?
No, that we can't do, but I can do a bond with a GPS.
Bond with a GPS. Can we do ROR with a GPS if the court's insisting upon a GPS?
I'm not gonna do that. There's gotta be something there, but remember, I can waive cost of installation and fee.
Could we do $1,000 per count with the GPS? Now, just to clarify, and I want corrections to be real clear about this, she is not being placed on pretrial services. It's just a condition of her bond?
Correct. That's what it is. It's part of her release conditions, is that it would be GPS will make it level two.
Can we do level 3, please?
I don't want to do level 3. I mean, we've already got, I don't want a situation where she has the ability to be roaming all around. Level 2, she certainly can be able to go to work. She can deal with any medical issues, issues with the children. But she is going to have some type of a home base. You're going to have to find a place for her with this level 2.
She's going to stay with a friend. That's what she's going to do for the foreseeable future.
All right. Well, that's amenable. Any input from the state?
That's fine with the state, Your Honor.
All right. And now we need to have a stay away order. Okay. Apparently, I'm assuming JH is our victim. All right, Miss Bentley, you are to have no contact whatsoever with JH. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text or use social media to communicate with JH. Do you understand?
Your Honor.
Okay, good luck to you, ma'am.
Your Honor, what are the monetary counts, amounts per count?
1,000 each, total of 3,000.
Got it. Okay, thank you, Your Honor.
Thank you.
Plus, it's plus, yes. Okay, thank you both. That took care of Bentley. Andrea Roa. Is this Miss Fernandez's? No?
Judge, mine is Gomez. I don't know what's going on.
Brian, I go with what they give me. You know
Gomez
what?
is next.
Which, you want to do Gomez? We can do Gomez.
Please, thank you.
All
Yes.
right. Ivana Gomez.
Good afternoon, Your Honor. Laura Adams on behalf of the state. Also
Good.
present in the Zoom court is Allison Frieden and Rachel Kipnis. Ms. Kipnis was the victim's cousin. Ms. Frieden was the victim's lifelong friend. They met back in preschool, just to let the court know they're here. Also, Detective Chadwell, who's the lead on the case, is also available on Zoom. She's monitoring, but she's not a panelist at this moment.
Okay.
And Lauren Fernandez, once again, on behalf of Miss Gomez.
Lauren, does she speak English?
I believe so.
Señora, buenas tardes. ¿Habla usted inglés? Ma'am, good afternoon. You
Yes,
speak-
I'm here. I
Okay.
speak English.
Okay. Just for transparency, I do know Ms. Kipnis as a member of the Florida Bar. She has appeared before me as well. I can still be, fair and neutral in this matter, but defense, I just want you to be aware of that.
Yes, Judge. And of course, I extend my deep condolences to Miss Kipnis and Miss Frieden as well for their loss.
Thank you, Lauren, and thank you, Judge.
I'm sorry, I guess, Ms. Frieden, what was your relationship? I thought you were there on behalf of the state. Maybe not.
No, that would be me, Judge Laura Adams.
You are. I know you are. With you because she used to be a prosecutor as well. So,
I
Ms.
know.
what was your connection? I apologize. I didn't hear it.
I'm a lifelong friend of Katie Kipnis, who is the victim in this case.
Okay, I did not hear that. I apologize. And again, my condolences as well. And to Ms. Fernandez, I do know Ms. Frieden as well. As an attorney, she appeared before me as well. And I just wanted to be transparent about that. So are we ready to proceed?
The state is ready, Judge.
Okay, so give me a second. All right, ma'am, you are charged with leaving the scene of a crash with death, resisting an officer without violence, and that appears to be the 2 charges. Give me a second as I review the arrest affidavit.
Your Honor, I have not seen the arrest affidavit. I did email early this morning requesting it from the clerk, but I don't believe I'll be making any arguments as to probable cause anyway. So.
All right, the court has reviewed the arrest affidavit and does find probable cause. I will hear argument.
Judge, the state would argue that this defendant is an absolute flight risk and a danger and a menace to the community. I would point out that she passed a police officer who was in a marked patrol car. She was going so fast that Officer Angel Fernandez had to go about 100 to 110 miles per hour in order to ultimately catch up to her vehicle. The speed limit at that stretch of 7th Street is a 30 mile an hour. And although we have not yet had an opportunity to download the black box of the vehicle, I believe that will be done today. I have a search warrant from Detective Chadwell to review and to provide to a judge. Early estimates are that she's going at least twice the speed limit. In addition, Judge, when she struck Miss Kipnis, she hit the victim so hard that the victim's head went into the vehicle through the windshield, and some of the victim's hair got caught on the passenger's seatbelt of the defendant's vehicle. There are photos of the vehicle from the scene as well as at the secure tow yard where it's at. I forwarded those to the assistant state attorney that is in your honor's courtroom. I can also forward them via email or text to defense counsel. I have them available if the court would like to see those. I would point out, Judge, that the victim was hit more or less at about the intersection of 7th Avenue and 27th Street and 21st Avenue. She was inside the vehicle. The defendant continued for about 231 feet until she swerved to the left, which dislodged Miss Kipnis from the vehicle. The defendant then continued for about another 4 blocks, almost a half of a mile. And the only reason why she stopped is because of the traffic that was at the Beacom Avenue intersection. Had it not been for that traffic, I imagine that she would have continued, and it would have been at such a high rate of speed, Officer Fernandez may have had to disengage from the pursuit. When they were able to take her out of the car, as your honor may have noticed, there in the arrest affidavit, there was fresh vomit in the vehicle. She refused to give a sample of her blood, so they had to do a forced blood draw due to the exigent circumstances. The investigators thereafter obtained a search warrant where they got a first blood draw, and then for the second one, she again refused, hence the charge for resisting without violence. She is absolutely a flight risk. I would also point out, Judge, just the driving pattern alone, the disregard for human life, it's hard to calculate. Her comment that this was, quote, just a homeless person and that this was only an accident to the investigators is shocking. Even if, hypothetically, Ms. Kipnis had been homeless, no homeless person deserved to be treated the way this defendant treated that woman, but she was anything but. I would also point out, Judge, that this defendant had a terrible driving record. In Broward in 2021, she was found guilty for an unlawful speed in a school zone, traveling 33 miles per hour in a 15 mile per hour zone. I would point out in Dade County, she got tickets in April of 2015 for an improper lane change. Given the fact that it was dismissed for a civilian failing to appear, I suspect that was a traffic crash, but I don't know for certain yet. She also had 2 speeding tickets in February and June of 2017, which were dismissed either because the officer failed to appear or for a defective citation. She was found guilty for failure to yield the right-of-way at a stop sign. That ticket was issued on April 5th of 2019. She was found guilty. In 2020, she had another speeding ticket that was dismissed. In February of 2022, she had another speeding ticket that was dismissed on speedies. And just last month, Judge, she was found guilty for a violation of the handicap parking law. So this is a person who has no regard for human life, who is a flight risk. And for all those reasons, Judge, and because I do fully anticipate that charges of vehicular homicide and likely DUI manslaughter are forthcoming once we get the black box data and the toxicology reports back, which will enable the state to file a motion for pretrial detention. I'm asking this court to hold this defendant on $1 million bond And in the event that she is able to make that bond, I'm asking that she would have to surrender any passport, that she would be on total lockdown house arrest. And of course, a no driving order.
May I respond?
Yeah.
Your Honor, my client has no contact with the criminal justice system. I don't believe she's ever been arrested in her life.
Oh, Judge, I'm sorry. If Ms. Fernandez, please forgive me. I did neglect to also point out that in 2016, she was arrested in Monroe County for a misdemeanor possession of marijuana charge.
And how did that case turn out?
It's hard to say because it's an out-of-county prior, but according to the criminal history that I'm looking at, it says disposition other. It says time expired restriction for non-criminal justice purposes per OCGA. I don't know exactly what that means.
Your Honor, like I said, I wasn't aware of any prior criminal history that she's had. She's a college graduate. She's a U.S. citizen. She has ties to the community. I believe her family is also on Zoom. I can't see them, but they're there participating. Um, the standard bond for this charge, I believe, is $15,000 if I'm not mistaken. And then $1 million bond is absolutely outrageous. I understand Miss Adams' point of view, and maybe she has proven probable cause for the charge, but certainly she has given nothing to indicate that she's a flight risk. She's a U.S. citizen. She has ties to the community. She works here. She's lived here her whole life. She has brothers, sisters, mother, went to college here and will continue to reside here. I understand if the court wants to place a no drive order for the safety of the community, that may be appropriate. But certainly $1 million bond is obviously tantamount to no bond at all, Your Honor. And if and when the state will file additional charges, the bond for those charges can be addressed at that time.
All right. Anything further?
No, Your Honor.
Your Honor, as a friend of the decedent, would the court consider public commentary?
If you wish. Yes, ma'am.
Your Honor, I'm a resident of the city of Miami where this took place. I believe that if this defendant is back on the streets, that I am in danger, the rest of the community is in danger. I just want to reiterate that the victim was an incredible human, a very giving person, participating in community and cultural events. And I do believe, just to reiterate Miss Adams' opinion, that she's a flight risk due to the weight of the evidence and the penalties in this case, where the minimum mandatories, where these charges carry and potential charges carry minimum mandatory sentences, and the weight of this evidence is frankly shocking and overwhelming. And as Your Honor knows, I too was a prosecutor. I've never seen a case like this with such evidence against the defendant. Thank you for hearing me as a member of the public, not in any capacity as an attorney.
Your Honor, may I speak briefly?
Yes, ma'am.
So I had the honor as a prosecutor to be supervised both by Ms. Frieden and Ms. Adams, and I certainly would not make a better legal argument than either of them did. But I will be filing a notice of appearance as victim's counsel on behalf of my family. And I just want Your Honor to be aware of what a shining light has been taken out of this world by the incredible irresponsibility of this defendant. And that Katie was an amazing person and so deeply loved by her uncle, who's my dad, who's sitting next to me right now, and her niece, who's my daughter, who loved her so much, and her father and stepmother and aunts and uncles. And the behavior of this defendant, and I was a prosecutor for years, shocks my conscience that someone would drive through a human being and swerve to get away with it, and then continue along the road. And if there is any argument for a flight risk, that's it. She hit a human. There is a Katie-sized hole in her windshield. and tried to get away with it. And her response, when she was finally apprehended, was, "I thought it was just a homeless person," which it is,
At all.
I can't imagine a more disgusting thing that someone could say in that moment. I appreciate your Honor's time this morning. Thank you so much.
I want to also echo my thoughts of the prosecutor that this is not just a leaving the scene of a crash involving death based upon the facts that I've seen in the four corners of this arrest affidavit. This most likely will be elevated to a much higher charge involving this death of this individual. If there is any indication of a flight risk, one need only read the four corners of this arrest affidavit and find that this defendant not only fled from the law enforcement officers as she sped past them in their marked patrol cars, trying to avoid capture, but the fact that even though she struck another human being, she continued on trying to escape, trying to flee. That, in this court's mind, is evidence of a risk of flight.
Your Honor, would the court allow the assistant state attorney that's in your courtroom to show you the photos that are on his computer? We can hold his laptop up to the up to the screen if need be for defense counsel.
And
Or I can share them with Ms. Fernandez.
Yeah, and Ms. Adams, if you wouldn't mind, and if you would also not mind sending me a copy of the arrest affidavit, which I still don't have a copy of.
If you would have let us know in advance, I would have had somebody.
I did, Judge. I put my name. I emailed the clerk this morning, and I let them know before they even started bond hearing that I didn't have the affidavit.
Mr. Morono, my colleague, are you still in the courtroom?
Yes, this is Asa Tawari. Mr. Moroni and I are both in the courtroom. I'm presenting the judge with the photos on Mr. Moronio's phone. His laptop just appeared to shut off. But
If you're able to, we can do a viewing. That way, Miss will be able to see it. I can probably do a
Judge, yeah, if your honor would allow the share screen.
Yeah, I'm not really am I the host, or is there someone who's able to do that for me? I don't think I'm the host. Give me a second. Is our Zoom technician, are you still there? Do you have a host capability to share screens? Maybe try that. I just tried multiple presenters can share. Let's see if we can get that on. Right, I pushed that and nothing came up.
Your Honor, I really don't understand what the purpose of showing those photographs today has to do with a probable cause hearing at this juncture.
It has to do with the court's ability to determine what is an appropriate bond, if any, to set for the defendant, as leaving the scene of a crash involving death has not been designated by the legislature as one which is eligible for pretrial detention. It is incumbent upon the state to explain to the court why I am asking for $1 million bond, which as a prosecutor of 31 years, I have really never done before. I've been handling traffic homicide cases for more than 20 years. I've never asked for $1 million bond in a case before.
All right, are we able to share this for the defense to view? Are you able to do a share?
Yeah.
Miss Adams, do you have something where you can share it?
I believe that I can now. One moment, please, Your Honor. Is Your Honor able to see a photo at this time?
Miss Fernandez, are you able to see this?
Yes, it's not as large as the screen, but I could see the windshield. Yes.
Okay, so that is at the scene, Your Honor. One moment, please. This is the vehicle at the storage yard where you can see how the victim's body traversed up the hood of the car and through the windshield. This is a closer photo to show how completely the victim's body went through the vehicle. And lastly, Your Honor.
Hold on, the only thing that I've
Yeah, there's only one photo, Miss Adams.
Oh, hold on one moment. I'm so sorry. Let me try this again. I don't. One moment, please, Judge. Your Honor is not able to see the photo of the vehicle in the storage yard?
When you click share, if you click on the actual image, it'll just share that one image. If you click share your entire screen, when you change your screen, when you change the image, it should change the image.
Okay, now I see a second image of it looks to be a garage of some type now.
Thank you for the technological assistance. This is the vehicle at the secure lot where it's stowed pending obtaining a search warrant. Here is a closer photo of it, if Your Honor can see that.
I do see the close-up image of the vehicle in the garage.
And this,
I don't. I just see the one in the actual garage.
That's it. With the
right, it's the same photo, it's just closer. And I am now trying to share, if Your Honor can see the vehicle seat.
Not yet.
One moment. Says my sharing is paused. Is the court able to see a photo of the interior of the vehicle now?
I see it.
If Your Honor can see where I'm moving the cursor, that is hair from Miss Kipnis that got entangled in the defendant's front passenger seatbelt. I think $1 million is more than justified, Your Honor.
Once again, Your Honor, it's tantamount to no bond.
While I certainly understand the state's position, the court cannot give at this juncture something that is tantamount to no bond. While certainly the facts and what I have just seen and what I have heard and what I have read points to someone who should not be out on the streets of Miami. And I just look to this statement that she's alleged to have said that it was just a homeless person that I hit and it's just an accident.
Your Honor, I never said that. I did not say that whatsoever. That's
Fact.
false.
This is what is on the arrest affidavit, and
I did not say that. I said it was an accident. I didn't say anything else.
You don't need to be speaking, ma'am.
Okay.
court is going to issue a $250,000 bond plus house arrest, total lockdown. You are not, if you do get out after a $250,000 bond, you are not to leave your home at all.
Not even to work, Your Honor?
I will, the division judge will address it at that time, but as of right now, no. And it would be, I'm sorry, what did you say? Well, that would be as to count one. As to count two, we can include that with it.
You want to just ROR her? It's resisting.
ROR, it would be 250,000, and then I'm not going to ROR. I'll do $1,500 on the resisting without, plus house arrest, total lockdown, and
Judge, the state was also asking that she has to surrender her passport.
not done yet. I'm not done.
Do you have a passport, ma'am?
I do.
All right, you will surrender the passport.
And that's prior to bonding out, Your Honor?
Correct. And in addition to that, there will be a no drink, no drive order. Good, you got this. All right, anything further on this matter?
No, Your Honor, thank you.
Thank you very much. Thank you very much, Your Honor. Once again, my deepest condolences to the family.
Thank you, Lauren. Thank you, Judge.
Thank you.
Come on now. Come on. This is the last female right here.
We did have one other female. You want to just take care of that?
Yes, Jennifer Roa, Judge. Andrea Roa. I'm sorry. Andrea Roa.
All right, Andrea Roa, you are charged with possession of a controlled substance and possession of drug paraphernalia with intent to use. I'm reviewing the arrest affidavit. Court finds probable cause.
Judge, I see that she has no prior convictions, or it looks like an arrest.
Do you have anything, State?
And let me see. I don't think she's ordered into pretrial services if she qualifies.
All right, I'll go ahead with pretrial services. Alternate bond as to count 1, 2,500. Alternate bond as to count 2, 500. We have apparently a juvenile. Do we have? Can we let them wait, or we need to get to them? We need to get to them. All right. Oh, yeah. I guess so. It's.
Your Honor, where do you want to do that? 4-1 or 6-2? For Zoom?
I have to go down to 4-1. Yeah, I have to go down.
No, I mean for your Zoom though.
We're doing it. Yeah, it's working. 4-1 is now working.
Okay.
I gave, what did I give? 1,500 on the second count? So yeah. Right. Okay, we need to take a short recess. I got to get back to juvenile. Okay, are we good for now?
Yeah.
All right. You're coming down, or you don't need to come down? Is it a delinquency? Yeah.
Yes, so you will be there.
Okay. Oh, gosh. This way. Which one?
Juvenile.
There's only one case. There's only one case, so it should take.
I don't know, that tastes good. Half an hour.
I don't think her this long.
Well, if it's any condolences, he's the very next person.
I understand. I ain't got nothing to do with that. Okay.
Yeah, I've seen that name. I'll show you. I had to look it up. I know this face. I know Miss Gibbons. That's the thing. I know Miss.
I don't know.
I know that's what happened. On vacation, or like at conferences. Diversion.
They're gonna come back, they're gonna come back and make some sad. You have all that anymore. I left my pen there. We borrow them. Be right back.
F1, they can draw F1. What is the difference? They don't pre-try to teach you for that.
They're supposed, it's an F1. That's supposed to be no one.
That's what I said. I said, no, why? What's the problem?
They weren't trying to case. It was the two people who were the was one from the state and the private attorney. And that's why I just go back and forth because that state attorney probably is used to break the. Yeah. And that's what I thought was a pre-shot. No, it was fun. That was great. Not that last case was just so. Yeah, I'm putting in the Boston. I know the Boston. That's today.
That's what. For a long time. And that's what he was. Now he's officially the judge. That's it. Thing about you is that the one that has the two pieces of your. There's one pair, two pieces. All right. There's one pair, two pieces. Yeah. On the box and then from the direction. No.
See, what's what we got? Whew, we're ready to go. Let me know if everybody's ready.
State's ready.
Okay, what was the next one that we had? Okay.
This whole.
This thing. All right, let's call Zachary Mickens or Zach Berry. All right, do you want to waive reading of the charts, counsel?
Yes, Judge, it's fine. And well, I'll give you a chance to review the arrest affidavit, but I would be asking for a release on his own recognizance under these circumstances.
You just speak a little louder.
Sorry, I'm getting over having a cold and I'm not speaking up. I'm asking that he's released on his own recognizance. I don't know if you've reviewed the arrest affidavit. If you haven't, I'll let you read it now based on the circumstances.
All right, court does find probable cause. Let me hear from the state without, as far as release conditions.
Your Honor, I mean, we would be objecting to an ROR simply because in 2017, there was a conviction for the same charge that we're here for today.
Can I speak up on that?
Yes.
We went.
Oh, hold on, hold on, hold on.
It's up to the court.
Hold on, just 1 second.
Judge, with respect to this, it was one day. It looks like he was clearly trying and intending to register by the end of the month. He just came on the 30th instead of the 29th. I know he was maybe.
I was there on the 29th.
This, I don't have a problem with an ROR. I'm going to ROR the defendant. Now,
Judge,
just want to make sure that you have your address up to date. I've got, it's showing as homeless. Do you have an address?
No, I'm homeless due to the circumstance of what I have to deal with.
Well, we got to get, you know what?
I got a mailing address for if I get a subpoena.
Well, what's the address?
Actually,
Do you have an address?
Miss Davis there.
Raise your right hand to be sworn.
From the testimony I'm about to give you the truth, the whole truth, nothing but the truth, so say I do.
Yes,
Okay, just tell us your full name.
my name is Melanie Davis.
Okay, Ms. Davis, are you allowing Mr. Mickens to reside in your home, or do you have a home that you can use to get him notice?
I let him come and bathe and stuff like that, but if he have to use the address, he can use the address. It's no problem.
Okay, because Mr. Mickens, I mean, if we send the notice to your address, to this address, that's notice. You're gonna have to show up. You understand that?
Oh, no problem. She gonna make sure I get it.
All right, what is the address?
650
650.
Southwest,
Uh-huh,
28 Terrace,
okay.
Fort Lauderdale, Florida, 33312.
And that's a house?
Yes, it is.
And your name again is?
Melanie Davis.
Melanie, how do you spell the last name?
Davis.
Oh, Davis, okay,
Yes.
got it, okay. All right, sir, good luck to you.
Thank you.
Shilek Rothwell. All right, Mr. Rothwell, you are charged with 1 count of possession of cocaine within 1,000 feet of a school.
Yes, sir. Hey, Judge.
Hold on.
I don't recommend saying
I'm
anything,
sorry. I'm
but
sorry.
that's my advice.
I apologize.
Possession of cannabis within 1,000 feet of a school. All right.
But I do have a couple of cause arguments.
Yes, sir. And I was gonna say I commend you for being able to deal with all of these people hollering at you and stuff. But yes, Judge. Okay, first of all, my co-defendant.
Again, I don't recommend that you say anything in the record.
Okay.
Judge, are you willing to hear
Yes,
Mr.
sir.
Rothwell or defense?
I don't want you talking about the facts of the case. You better listen to your lawyer's advice, because the state attorney will be taking everything down that you say.
Yeah, but I'm speaking the truth that I still continue to speak, Judge. But my only thing about this, what I'm saying, is that none of this was in my possession. You understand? It was in the vehicle, and I was getting a ride.
That's actually the argument defense counsel is going to make.
Yes, because the vehicle was a rental, and my co-defendant.
Suggested you let me.
I'm sorry. I'm to apologize again.
Okay.
I apologize.
It's in your best interest.
Yes.
He's reading the arrest affidavit.
Because I know how it looks.
Okay.
That's why I don't even do drugs. I'm an artist, and I know how it looks.
All right, the court is finding probable cause. Now, the state is filing a motion for pretrial detention.
Yeah.
Judge, are you willing to hear my argument?
Oh, well, where do you see trafficking?
I don't see anything with the trafficking amount.
Hold on.
And also,
Hold on, let's just, I think he's looking. All right, you withdrawing your motion for pretrial detention?
Yes.
Okay, it is withdrawn.
Judge,
All right, talk about priors. What do we have?
Judge, I am asking if you would reconsider your ruling on probable cause, just given that Mr. Rothwell was not the driver of the vehicle.
It says he was the driver. Defendant driver.
Make contact with driver of vehicle.
Exactly. Officer Alvarez made contact with the driver of the vehicle, defendant.
My apologies. My other argument that still stands, though, is that these items were not found until after there was an inventory search done, and it was the jointly occupied vehicle. Therefore, he may have only been in constructive possession. There's nothing found on him. He may have no admissions, and there's another party in the car.
But again, 4 corners of this affidavit, he is the driver. It was found within various areas of his vehicle. I'm going to find probable cause. Now,
So
let's
Your
talk
Honor,
about priors.
As far as priors, there was so we have felony assault with serious bodily injury from, what county is this? Robeson County.
He's not.
Correct. Display weapon, felony.
All right.
Felony larceny. It's
I understand. The court is going to give bonds as follows: is to count one, it's going to be $5,000. As to count $5,000. As to count three, $5,000. And as to count four, $5,000.
Can I ask what county the priors were out of that were just read into the record and what year, if the court would consider an alternate of house arrest? Along with the cash bond.
I have a Normanton, North Carolina address. So he's not eligible for house arrest. Okay,
Understood.
thank you. Let's go to the next one. Luis Maldonado. Okay, you need to do there.
You want redress?
Good afternoon, Judge.
You've just been arrested, okay?
So what do I have to do?
Your attorney will talk to you once you get on the line. Mr.
Maldonado. Good afternoon, Judge.
It's not an arrest warrant. Good afternoon.
So Judge, I'm seeing that this is just for the warrant being executed and it's for $10,000.
Right.
I'm reading it. 1 second. This is.
I did 90 days.
Give me a second. This defendant is Maldonado.
That's correct.
Cedric Farr. I see, got it. Got it. Okay. So we just need to give it a $10,000 bond.
I would ask the court to consider lowering it to 5,000, given that Mr. Maldonado is indigent. There's no new crime alleged. There's nothing within the four corners of the arrest affidavit to say that he was absconding or evading arrest. And he informed me that he does have 7 children, 3 of which he does directly pay child support for.
Yeah, no, I'm going to decline that. As to count one, what I'll do is I'll make that count one $5,000 and count two $5,000.
Thank you, Judge.
So 5,000.
It's 10,000 total. 10,000 per count.
Okay.
Albert Orochek Garcia.
Yeah.
Bond out.
Okay. We did right in the back of the. Here.
Good afternoon, Your Honor.
Mr. Grant?
Yes, ma'am.
This is Mr. Grant, Christopher.
Yes.
Grant.
Good afternoon, Your Honor.
With 2 counts of petty theft, 2 more convictions.
Yeah.
Court finds probable cause. And it will be $5,000.
You have 2 cases, Your Honor?
Lot of priors. Yeah. All right, sir, you are to stay away from the Walmart located at 21151 South Dixie Highway. You cannot be within 500 feet of that Walmart. Do you understand, sir?
Yes, Your Honor.
Good luck to you.
I'm sorry, Your Honor, is that $5,000 on each case?
How many?
I have 2 cases.
There's 2?
Yes.
You're right. It says it right in front of me.
So I think there's 1 charge per case. With standard bond being 2,500 per case.
You know what? I think I saw something in there. You know, that's the problem. It's not healthy snacks. All right, so as to case number F25-11026, also reviewing the arrest affidavit. Also find probable cause, $5,000.
So is that 5,000 total or
No, 5,000 for each case.
So an elevated bond, you're not going to consider 2,500 per case?
No, ma'am, not with these priors. And sir, as I mentioned before, you are to stay away from that Walmart location. Stay within 500 feet. Let me see. Oh yeah, this stuff.
They arrest you for petty theft.
Yeah. I used to live off this stuff, but no more. Mauricio Bergueno.
Good afternoon, sir. Mr. Bergueno? I have reviewed the arrest affidavit.
Sir, you are charged with battery on a person 65 years of age or older.
Does he need a Spanish interpreter or not?
He does not need an interpreter. I do have a probable cause argument, Judge. Judge, I'm asking that you do not find probable cause for battery on an elderly individual in this case, and that you release Mr. Bergueno on his own recognizance.
What
was that?
Are you saying as to the age or just in general?
As to the age, as well as in general. So there's nothing within the 4 corners that has any indication of what age the alleged victim was. While there was the mother or the wife as a witness saying something different, the alleged victim himself said that it was a skirmish. And Mr. Bergueno said that he was put in a chokehold first. So it seems to me that
there's all this information. I'm just looking at the 4 corners of this affidavit, and I see that this defendant exited his vehicle and initiated the physical confrontation.
For Mr. So the second.
Bueno.
I'm so sorry, Judge. I was mixing this up with a different case. Please strike all of that. For this case only, there's nothing that says the age.
That I do not find probable cause on the 65 years of age or older. However, I find probable cause as to the battery. It is going to be a $1,500 bond.
Thank you, Judge. I apologize.
Okay. And we have a stay order, yes. And sir, you can have no contact with Jesus Ortiz. That means no direct contact or indirect contact. You cannot call, write, text, use social media, or attempt to communicate through a third person. Do you understand that, sir?
Yes, Judge.
All right, thank you. Then we go to Rui Mota.
Mr. Mota's on felony bond.
Okay. Who's the Division 17? Who's this? Cabarga?
Cabarga.
You can sit down. Yep.
All right. Charged with petty. Oh, he's not there. Good.
Good afternoon, Your Honor.
All right, good afternoon. You are charged with petty theft, 2 or more convictions. Court finds probable cause.
Remember, I wasn't trying.
The
Judge, I'm asking if you would give him a dollar bond, given that he's going to have a hold on the strong arm robbery case in division.
Nope, I will not. $2,500 bond, and there is a hold for Judge Cabarga.
Okay.
And Mr. Mota, you are to have no contact with this address of 13890 Southwest 56th Street. You cannot be within 500 feet of that location. Do you understand that, sir?
Yes, yes, sir.
Good luck to you. We go to Ronald Ferrer. Yep. I got it. Let me know when he gets there.
Mr. Ferrer?
Okay, Mr. Ferrer, you are charged with petty theft, 2 or more convictions, and resisting an officer without violence. Court finds probable cause. There are a lot of. All right, as to count 1. Going to elevate it $3,500. As to count 2.
My apologies, Judge. Mr. Ferrer speaks Spanish.
Oh, I didn't realize.
I didn't realize that either because he had said hi to me in English, but
David?
Yes, Your Honor.
Okay,
What's the charge?
He's charged with petty theft, 2 or more convictions, and resisting an officer without violence.
Usted tiene una acusación de hurto en cuantía menor con ya 2 condenas previas por lo menos. También se le acusa de resistir el arresto de un agente, más sin embargo sin violencia.
And I find probable cause.
Su señoría está determinando que hay motivo fundado ante dicha acusación.
Based upon the amount of priors and recent priors, elevating it to $3,500 on count 1 and $1,000 on count 2.
Basado en sus antecedentes y basado en que muchos de los antecedentes son recientes, su señoría está elevando la fianza a 3,500 y la otra acusación a $1,000, de 3,500 y $1,000.
Judge, given that Mr. Ferrer is indigent and is a petty theft, I'm asking if you reconsider and leave it at standard bond so that it's not tantamount to no bond with an elevated bond that he cannot afford.
I'm going to respectfully deny that.
Su abogado de oficio está pidiendo, debido a que usted es un hombre indigente, que le mantenga las fianzas en el monto de rigor, porque aumentarle la fianza entonces sería básicamente denegarle fianza. Su señoría está, con todo respeto, denegando el pedimento.
All right, we go to Carlos Oscar Garcia.
Usted se puede marchar, señor. Carlos Oscar, ¿hablas inglés?
Good afternoon, yes. Good afternoon, Your Honor.
Good afternoon. You are charged with 1 count of strong arm robbery.
Judge, I do have a probable cause argument for
Go
this
ahead.
as well. The alleged victim in this case is Mr. Garcia's wife. It looks like the property involved would have been joint property. We don't know who was paying for the cell phone, if it was actually a joint ownership, given that they are a married couple and live in that same residence. So I'm asking that you, at least on his own recognizance, if that is denied, I would ask for pretrial services.
State.
Here, one moment while I pull up the statute.
It's not a question of the statute. Do you have any argument as to the facts?
I mean, Your Honor, Defendant forcibly took the cellular phone from the victim's hands. Dude. And nothing from the affidavit states that the defendant was the actual owner of the cell phone.
All right, the court is reviewing the four corners of the arrest affidavit. The cell phone is identified as her cellular phone. That's the words used by the police officer. And that the defendant forcibly took cellular phone from her hands, preventing her from calling the police. She did appear to have a superior, not only possessory interest in it, but ownership above the defendant. Therefore, the court does find probable cause. And then I will lower the bond. I'll make it $1,500 bond for strong arm robbery with a stay away order. Mr. Garcia, you can have no contact whatsoever with the alleged victim. She's known by the initials of MF. Do you know who that is?
Yes.
Okay. You can have no contact with her directly or indirectly. You cannot call, write, text, or communicate through a third person. Now, are you living in the same home now?
That's my home. That's my house.
Have
I'm head of household.
You're going to have an issue.
She doesn't work. I'm head of household. I work. I pay all the bills. I have all my tools in that house to work with.
I'm letting you know for right now, though, because of these charges, because of these allegations, you're going to have to move out of the home. I'll give you the opportunity. Why do we have this as a non-domestic? I mean, it's his wife. Why are you giving me a non-domestic?
She invoked Mercy's law, Your Honor.
No, but you're giving me a non-domestic.
Judge, I will have our office explain about modification of a stay away order if the alleged victim is interested and reaches out to us. Are you denying my request for pretrial services in the alternate?
Well, that doesn't make it. What does that have to do with whether or not he gets into his home?
I was mentioning the stay away order as far as that could change things. I'll explain it to him, but for these purposes right now, obviously there is a stay away order. So
the stay away order in place, that means he's going to have to find another place to live. So you'll need to discuss that with him, but I will give him the ability to remove any items, personal items, in the meantime, with the assistance of a law enforcement officer.
Understood. And are you denying a request for pretrial services as an alternate bond?
You know what, let me see.
He has no priors, Judge. I mean, it seems like, I'm not making light of it, but some sort of marital argument, and that there was probably more to this going on there.
I'll tell you what, I will go ahead and make it pretrial services, alternate bond, $1,500 with the stay away order. All right.
Thank you, Your Honor.
Okay, but I do need to make sure that you understand you have got to stay away from her as well as that location of the residence. It appears to be 12071 Southwest 253rd Street. You will be allowed to go there to get personal belongings while this case is pending with the assistance of a law enforcement officer. All right, good luck to you, sir. Then I have Terrence Sutton. You are charged with 1 count of possession of cocaine and driving with a suspended license.
I believe we already addressed the bond on the DWLS earlier.
All right. Court finds probable cause. And that's as to count 1.
Is he eligible for pretrial services, Judge? I don't see that he has any local priors.
I apologize, Your Honor. I do have national priors. Fulton County, there was a conviction, financial identity fraud.
Sorry, pretrial services alternate bond 2,500 and, he's what?
Can you make sure he's not hungry?
Oh, well, I have, sir, what's your address?
It's 3175 Sea Grape Road. I just purchased, well, just moved to another house.
Is it Miami?
Where
No,
is it?
Palm Beach.
Palm Beach.
But I still have my parents just there. I'm going through. I still have address.
Do you have residency in Miami?
Yes.
Okay.
I do.
What is that address?
10351 Southwest 183rd Street 33157.
Okay, we're gonna need to hear that again. So it's 10351 Southwest 183rd Street, Miami,
Yes, 33157.
33157. Is that a house?
Yes, it is.
All right, so that's your address as well. All right, we'll do pretrial services.
But can we have the mail?
500.
Your Honor, would you like to include the traffic? You gave him straight bond of 150.
Sure.
Okay.
Okay, you need to change that with me, or you can do it.
The bond hearing clerk has to put it in CJIS. The case number is AL97LUE. It's a DWS.
What was the bottom of the
150. 150.
So it's pretrial services. Okay, thank you. Roberto Gonzalez.
Bond out, Your Honor. Humberto Gonzalez bond out.
David.
Oh, yes. Yep.
All right, Mr. Carroll, you are charged with one count of destroying memorial or historic property.
Yeah, it's rough.
And Judge, I do have a probable cause argument as to that.
What's that? Okay.
Judge, my understanding from the statute is that there has to be a maliciousness found, some sort of ill intent. From my understanding of the, reading the A form, he did not have any malicious intent. He said he was an artist. In fact, it looks like, and I could be wrong, but from normal reading, he was attempting to cover up a swastika. Whether that was part of the memorial or not, I'm not sure, but that he was covering it up.
It wasn't. I
That
noticed
he
it.
was,
I'm sorry.
I wouldn't
I
speak. I
apologize.
wouldn't speak on the record.
Please, no, I'm
And that he was an artist and was not trying to damage the property in and of itself.
All right, well, I have an address of 1200 Ocean Drive. I'm trying to figure out where it's showing that there is a memorial or historic property. Can somebody point me where it, okay, he was drawing on private property and in an Art Deco historic building. Consistent with. It says anti-gravity. Is this an anti-graffiti? What is anti-gravity drawing?
This is funny.
I need to see the statue. Somebody have a, a rule book anywhere here?
Well,
It's not, it's only one volume of it. And it's, I need volume 1. I only had volume 2 in there.
I mean, I can read it for your honor.
Oh, wait, what's this? Wait, there's another. Oh, wait. What is this? This is also volume 2. Volume 1's an older one, but I'll take it. All right, so what's your numbers? All right, so it's 806 with 1352. Building, sure. Roof one. You know, and I don't see it. Steve.
I also don't see any
Corey.
amount established, Judge. It has to be with more than 200, but less than 1,000.
I'm sorry, what were you saying, Council?
My apologies. I was making probable cause argument as to the felony, but as to the criminal mischief itself, he's charged with an M1, a first degree misdemeanor.
All
So
right.
it has to be more than 200, less than 1,000, but there's no monetary amount of damages listed within the arrest affidavit.
So what I'm gonna do on count one, no PC. On count two, I do find PC. And so the defendant is ROR'd on count one. As to count two,
Are you fighting probable cause for a misdemeanor in the second degree or first degree, Judge?
well, it didn't give me an amount, so it's gonna have to be a second degree.
Right.
Yeah, so it's second degree. Well, second degree is the 200 less, correct?
That's
Second degree is 200, or it should be less than 200. Was arrested for a first degree misdemeanor.
Value, does the state show anything of a value?
No, you are.
Does he have any priors? I don't see anything here other than null pros on a.
Correct, on an ordinance.
All right. I'm gonna give him pretrial services. He's homeless. Can we get him into TAP?
You're releasing him on the felony count, Judge. I mean, I would ask if you release him on second degree misdemeanor as well.
Well, I'm gonna give him TAP. With an alternate bond of $500. Count two.
Now, one would be released outright, Your Honor, if you have no PC?
No PC.
Would you consider $250 as to the monetary bond for count two, Judge? I think that is standard bond for a second degree misdemeanor.
No, it'll be 500. And Mr., I want to do a stay away order from at least this location. There it is. Okay. Well, what's KG? Who's?
It was the owner of the home, I believe, Your Honor.
It's a home? It was a memorial of some type or it's a historic building.
I believe he's the owner of the building, Your Honor.
He is listed as.
Well, I want the address then and this. So,
Okay.
All right, sir. You are to have no contact with the owner of the home who is listed as KG, as well as the building, which is 1200 Ocean Drive. You cannot be within 500 feet of that location. Do you understand that, Mr. Carroll?
Yes, Judge.
Okay.
Thank you, Judge.
Thank you.
How long do I stay in jail?
Lubin Arcelia. All right, Mr. Arcelia, you were charged with grand theft of a vehicle and no valid driver's license.
Arcelia habla inglés.
Do you speak English?
Yeah.
Different face that.
Court finds probable cause. What do
I
we
got
have?
your standard bond, Judge. I think he has an open.
There are two open cases, one for resisting without violence and another is a trespass. He also had a no action felony burglary from this year. And
All right, so we'll hold on these open cases, which, who are they? This is F25, no, B25 4634.
right. Section 202. Wouldn't that be?
And M255717. Yes. These charges, $2,500 for count one. Count two is $500.
Your Honor, you addressed the MV deal. You gave him a bond of 150.
Oh, you got lucky. Okay.
And count one, you said 2,500?
Yes,
And a hold on the two misdemeanor cases?
ma'am. Thank you. Jamal Bodden. Oh, wait, Mr. Arcelia. Mr. Arcelia, you can have no contact whatsoever with Stella Dwornitsky. That means no direct contact or indirect contact. You cannot call, write, text, use social media, or attempt to communicate through a third person. Do you understand that?
Yes.
And in addition, there's our second one, Jonathan Francois.
Sorry, that's very new.
Just for the next one. Okay, never mind. That was a just kidding moment. All right, then we go to Jamal Bodden.
He refused court, Your Honor, reset for tomorrow.
Okay.
Camacho, come on, sir.
You said 6-1.
English?
Yeah, oh, yes. He needs an interpreter, Judge.
You are charged. Speak English.
Interpreter for Mr. Camacho, please.
All right.
Spanish.
You are charged with possession of cocaine and failure to have a driver's license motorcycle endorsement. You got that, Dave?
Bueno, se le acusa de, I was talking with, but never mind. Usted se le acusa de posesión de cocaína y también se le acusa de no poseer el endoso de motocicleta.
What's reviewing the arrest affidavit?
Su señoría está repasando el informe de arresto, la atestación de arresto, disculpe.
Court finds probable cause.
Su señoría ha determinado que hay motivo fundado ante la acusación o acusaciones.
I don't see that he has any priors, Judge, if you would consider pretrial services.
Pretrial services, alternate bond, 2,500 for the first. And pretrial services, oh, it's, no, you got the motorcycle endorsement.
Yeah.
Oh, we did it.
The deal expired, you gave him a bond of 150.
Got
So
it.
we can, would your honor want
Would you like to include that in pretrial?
Yeah, we can do pretrial services, alternate bond, 150.
And for the no motorcycle endorsement, Your Honor, what's that?
50, alternate bond, 150.
Ok, su señoría a través de la petición o el pedimento que hizo su abogado de oficio le permitirá salir con el programa de intervención o el servicio, disculpe, de intervención previa.
Your Honor, I'm sorry, I don't have a
Y si no
motorcycle.
califica, entonces tendría. Espera un momentito que los carceleros están indicando algo.
I don't have a motorcycle endorsement. Is that case number ALIDD1E?
Yes.
Okay.
Ok, ante las acusaciones que tiene, las fianzas alternas serían 2.500 por la posesión de cocaína, 150 por no tener el dorso de motocicleta, 150 por tener una licencia que había caducado. De nuevo, si usted califica por los servicios de intervención previo a juicio, no tiene que pagar nada.
All right, let's go to.
Ya se puede marchar, señor.
Ok, so, ¿cómo yo llamo para pagar la fianza?
So how do I call in order to pay the bond?
One of your attorneys will speak with you and corrections will speak with you on your bond options.
Uno de tus abogados va a hablar contigo y también los carceleros van a hablar contigo con respecto a las fianzas alternas.
All right, let's go to Jorge Leonardo Garcia.
Yeah, as a whole for immigration.
Señor García, ¿necesita usted intérprete?
No.
Señor García, ¿habla inglés?
No.
Ok, señor García, usted tiene una orden de retención por parte del Departamento de Inmigración.
You are charged with grand theft.
¿Usted se le ha acusado de hurto en cuantía mayor?
Court finds probable cause.
Este tribunal ha determinado que hay motivo fundado ante dicha acusación.
We have any priors?
¿Qué tipo de antecedentes tiene él?
No, Your Honor.
All right, pretrial services. Oh, all right.
Correct.
So it'll just be $2,500 bond.
Ok, el fiscal adjunto acaba de denunciar que usted no tiene antecedentes penales. La fianza va a ser fianza de rigor 2,500.
ATS said they won't take them.
Oh, I see.
El servicio de intervención previa a juicio no lo aceptará usted.
All right. And sir, you can have no contact whatsoever with the alleged victim in this case with the initials AJ. No direct contact or indirect contact.
Señor, usted no puede tener contacto alguno con la supuesta víctima, en este caso con las iniciales AJ. Usted no puede tener contacto directo ni indirecto con esa víctima.
You understand?
¿Usted entendió, señor? Señor, ¿usted entendió?
Sí.
Yes.
All right, thank you.
Gracias. Se puede marchar.
Ibrahimi.
He's a bond out.
Bond out. Linward McClyde.
Yes, sir.
All right, sir, you are charged with one count of, what, you want to waive reading?
Yes, Judge, we can wait the reading, please.
The court finds probable cause. He apparently is out on bond as well.
RR, Your Honor.
I doubt that. All right, defendant is out on bond, so hold, it looks like Division 4.
May I have the case number, Your Honor?
F25 6067.
Given that he has the hold, Judge, I would ask if you would give him standard bond on these charges or with an alternative house arrest standard conditions.
What is the sexual battery felony standard bond?
Well, actually, and Your Honor, the state did file, or is filing a motion for child detention in this case, as it is one of the enumerated.
All right, so the state having filed a motion for pretrial detention.
Also, Your Honor.
Is this going to be heard and or held for division then?
The final hearing on this pretrial detention hearing. And Mr. McClyde, you can have no contact whatsoever with the alleged victim in this case. Her initials are HW. You cannot contact her directly or indirectly. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate through a third person. Do you understand?
Yes, sir.
All right, good luck to you, sir.
Your Honor.
Don't just talk about the facts.
Your Honor, Your Honor.
Yeah, and that's no bond and hold for pretrial detention?
Yes.
This is for Division 4, Judge.
Correct, that's Brinkley.
That is my division, so.
Okay.
I'll be your
All
attorney,
right.
okay?
So,
Good for you. Got your lawyer with you at all times. It's good. All right. Music more. All right, sir, you are charged of violating carrying concealed firearm license. Let me read it.
I have a probable cause argument when you're done.
Speed. All right, I'll hear from your argument.
I don't know if I'm bad at math. I don't see what crime, there's no crime amounted in this arrest affidavit. It looks like he was born in 2002. We're now in 2025. He should be over 21 years old. And therefore does not need the license to conceal carry. And he's not on any probation. I don't see that he has any priors or anything else that would bar him from having that.
I'm not quite sure what, you're talking about the violation of the concealed license?
Yes.
All right, I'm looking at the statute 794.065.12A, and it says any potential buyer or transferee who willfully and knowingly provides false information or false or fraudulent identification. I don't have anything to say false.
Also, that judge, I don't see anything in the four corners of the arrest affidavit that he provided anything that was false.
I agree. I'm agreeing with you, State.
One moment, Your Honor.
All right, does he have any other priors?
No, Your Honor.
All right. I'm not seeing probable cause, and I just don't know if I'm not going to hold him for a day awaiting probable cause. I'm just going to release him. Defendant is released outright. No PC. All right, sir. Good luck to you. Franklin E. Address. Yeah, he did that guy. Okay. Well, whenever I release them, I want to make sure they okay. You are charged with one count of possession of cocaine within 1,000 feet of a church or convenience store, cocaine possession, and possession with intent to use drug paraphernalia.
Judge, I do have probable cause argument for the first count of possession of plus minus 2 grams. When I looked up the statute, I don't see that I see that the requirement for that is 10 to 20 grams as far as possession. I don't see plus or minus 2 grams as part of that statute. It has to do with intent to sell, having that amount with an intent to sell within 1,000 feet of a church or convenience store. Maybe I'm reading it wrong, but it seems to me that from the four corners of the A form, this would amount to personal use, not any other, there's no other facts that would establish an intent to sell, no baggies. It was contained into one pipe with a very small amount.
Okay, except as authorized by the statute, a person may sell, manufacture, deliver, or possess with the intent to sell a controlled substance within 1,000 feet of a place of worship. Okay.
All right, look, the court just finds possession, probable cause for possession of cocaine. It does say that it was within 1,000 feet of the convenience store. So it relates to that. If that is an element of that statute, the court does find probable cause, but does not find possession of drug paraphernalia with intent to use. It's just possession of drug paraphernalia.
So judges, as far as the first count, the possession with near
I
a
don't-
convenience store, that has to have with an intent to sell, and I'm arguing that there is no.
Well,
No,
you-
what defense counsel is saying is per the statute.
It says in the
893.
statute, possession with intent to sell.
Was yes, potentially in 893.131E1 does say that as authorized by this chapter, a person may not sell, manufacture, or deliver, or possess with intent to sell, manufacture, deliver a controlled substance not authorized.
So
by
the
law.
court then, as to count one, finds PC for possession of cocaine within 1,000 feet.
Is that in and of itself a separate charge? Because as he was, what he was arrested for, it's read into it that he has to have, they have to show that he had intent to sell it, not just possess it.
Is there a requirement for possession with intent to sell under that statute? Because otherwise I'll just do possession of cocaine.
No, it's sell, manufacture, deliver, or possess with intent to sell.
Right, so then that is the element. So then, under that statute, there is no PC, but the court finds probable cause for possession of cocaine only. As to that, it will be 2,500. As to count two, also 2,500. And count three, make it $500. Okay, thank you. Next one is Christian Santos.
Do you need an interpreter? No, man. Okay. You speak English, right?
Yes. Good afternoon.
All right, they're charged with possession of cocaine as well as possession of cannabis, 20 grams or less. Court finds probable cause.
Judge, I'm asking if he's eligible that he get pretrial services and a release on its own recognizance as to the possession of less than 20 grams of cannabis.
Now I'll go ahead and give them both. It'll be pretrial services, alternate bond, $2,500 on count one, pretrial services, alternate bond, $1,000 on count two.
You're raising count two to 1,000. I have 500.
Yeah, 1,000. It's an alternate. Hopefully we'll get into pretrial services. The next one is David Louisard.
Bond out.
Okay. Deshaun Breedlove.
NBC, Your Honor, reset for tomorrow.
Did you refuse?
NBC.
Oh, okay.
For Breedlove. Next one is Valentini. Oops, sorry about that. You got it. Good catch. You here? It had an NBC yesterday. All right. Sir, you are charged with one count of possession of cocaine and one count of possession of drug paraphernalia with intent to use.
I had no cocaine on me.
Judge, I do have a probable cause argument for Mr. Valentini.
Go ahead.
I'm asking that you release funds on recognizance as to both cocaine possession and drug paraphernalia with intent to use or possess. Within the four corners of the arrest affidavit, it is unclear who was actually possessing these items when the police arrived, because it does say, it says that when the police approach, without losing visual,
Well,
at
it said
first they observe, sorry,
that pipe in his right hand. Are there any prior?
The city sheet in my hand. I had it. It came to me.
What? What's the signal? Can I get? What? Yeah. Okay.
I don't know if we ever want to read all of them, but let's see the most recent. 2024 felony, petty theft, 2 or more convictions. And there was a.
All right. Court does find probable cause. As to count 1, 2,500. As to count 2, 500.
is he eligible for pretrial services?
He's not. Okay.
Oh, no, sorry, I said F-25.
Wayne Stokes.
This is an added charge, Your Honor.
Added charge, criminal mischief.
He received bond plus GPS on his other misdemeanor DV cases, and they added this new charge.
Mr. Stokes?
All right, Stokes, you're charged criminal mischief $1,000 or more. Court finds probable cause.
I would ask that he's not held on the underlying misdemeanors with stalking. It looks like this should be an added charge to the same facts.
Yes, that's what I said. It was an added charge.
Okay.
All right, anyway, in any event, it's $2,500 bond. The stay away order as well. Sir, you can have no contact whatsoever with Tralvin Bethel or Cassandra Davis Stokes. That means no direct contact or indirect contact. You cannot call, write, text, use social media, or attempt to communicate through a third person. Do you understand?
Yes, sir.
Judge Corrections is telling me that he has house arrest attached to the bond on the.
And it's also going to be included on this count as well.
He has bond plus GPS. He already posted the bond. He's waiting to go to house arrest, and they added this charge.
Okay, but I want house arrest on this one as well. And what was it, level 2?
Yes, sir.
Corrections, it was level 2?
I don't have the level, Your Honor, on the card.
Level 2.
Would the court consider releasing him on his own recognizance on this charge only, given that he's already posted the bond to the other charges? And with waiting release?
No.
Your Honor, so this one's going to be 2,500 plus GPS?
Correct.
Thank you.
And whatever the level was on the other cases. Okay, level 2, thank you. Christopher Pierre.
So this one I stand, right?
Right here. Yep,
Okay.
man, that's square. Good. Not evening yet. Haven't been here that long.
I'm here, you're charged with cruelty to animals with intent to injure or kill. Court finds probable cause.
No prior, Your Honor.
We ask for pretrial services if he qualifies, or standard bond of 5,000 if he does not.
I don't know if I want to put him in pretrial services. $5,000 bond. What is, do we know what the status is of the animal? Has the animal been taken into animal protective custody? Do we know?
According to the arrest form, Your Honor, it appears the animal services.
It says dog was removed. Okay, that's good. Steve Pierre.
Mr. Pierre.
Pierre charged with possession of cannabis within 1,000 feet of a school, possession of THC oils, as well as another possession of cannabis.
Thank you.
Court finds probable cause. There are a lot of drug arrests and some convictions as well. All right, it's going to be straight bond as to count one. $10,000 as to count two. $5,000 as to count three. $5,000.
As you know, he is indigent. I don't see that he has had a felony conviction in recent years, and all of his drug possessions do seem to be for cannabis, those that were resulting in a conviction, not any other more serious substance. The controlled substance here is THC, which is part of cannabis.
The 2022 sale of cocaine closed on February 23rd of 24. So, respectfully denied. Let's go to the next case. Jeremy Brown.
They do.
All right, Mr. Brown, you are charged with possession of a controlled substance, Molly's. Court finds probable cause.
Your Honor, there was a conviction for controlled substance as recent as 2022. For this defendant.
Well, I don't see that for him. Where do you see the 2022?
It is case number F21-20739.
Okay.
The close date was 2022.
Right. All right, probable cause, $5,000. Then we go to Leonardo Wallace.
And I do have a probable cause argument for Mr. Wallace, Judge.
Go ahead.
I think this is at best a felony battery, not an aggravated battery, given the allegations that he struck her with a open palm or an open fist, slapping her. And there was some punching, but there's no allegation that she suffered great bodily harm, permanent disfigurement, permanent disability, or that there was a deadly weapon used or anything like that. So I'm asking that you do not find probable cause for aggravated battery.
State.
Your Honor, there is an allegation that he grabbed her by the throat and pushed her down onto the couch. I know.
How is that an aggravated battery?
I believe there's an aggravation for strangulation.
That would be domestic violence strangulation, which is an F3 as well.
Yeah, but I don't see any evidence of strangulation.
That's also correct, Judge. There's no allegation that she lost consciousness. And at best, that would be a misdemeanor battery.
And strike her in the face 3 times with a closed fist as well.
And why is this not a domestic? There should be a domestic violence stay away order as well. So we need to get this changed.
Yes, Your Honor.
I think it's because, Judge, they have only been in a relationship for 3 weeks. Under the statute, they would have to have been living together or have a child in common.
That's right, yeah.
You may be correct, yep. All right, I thought they were living together. All right, the court does find a probable cause for a battery.
Misdemeanor battery, Judge?
Yes. Okay. Now, where is this threats to do bodily harm? It's to the LEO? Oh, the defendant may say when he gets out, he will kill the victim.
He will kill, no,
Kill the
to
victim.
the officer, That's threat Leo.
Okay, detective is
Threat law enforcement.
I see it.
Kidding, I will kill you the next time I see you.
All right, as to count 1, it will be 2,500. As to count 2, 2,500. Do we have a stay away? Do we have a stay away from the officer or no? I guess we really can't do it.
No, I don't think he can.
All right, sir, you can have no contact whatsoever with Kaylee Crooks. That means no direct contact or indirect contact. You cannot call, write, text, use social media, or attempt to communicate through a third person. Do you understand that, sir?
Yes, sir.
Right. Good luck to you. Spaghetti Bonnet.
How you doing? Good afternoon. Good afternoon.
Hi, Mr. Bonnet. You are charged with possession with intent to sell or deliver cannabis within 1,000 feet of a school and possession of cannabis. Okay, the court finds probable cause. As to count one, $5,000. To count two, $2,500.
Which would you consider giving standard bond of 500 as to count two?
Sorry, say it again.
The standard bond as to count two because it's less than 20 grams is $500. Would you
Right.
consider that?
I will lock it down to $1,000.
Thank you.
And I do see priors here as well. Mario Pillow.
This is an added charge, Your Honor. In his other case, retail theft, he was given tap with alternate bond of 2,500.
With all of these prior.
Mario, ¿hablas inglés?
Do you speak English?
Yeah, well.
Yeah, he speaks English.
He was given tap with all of these priors.
My understanding is that, yeah, yes, if there's these priors are, there's misdemeanors, but as far as the felonies, he hasn't had a felony arrest in what looks like about 5 years. That should, he does qualify at that point.
Well, when I see somebody with 3 pages of priors, it certainly causes concern.
Most of these are petty thefts, Judge, and possessions. He hasn't been arrested for a felony since 2019.
All right, let me just read the. All right, fine. Court finds probable cause. I will do against my better judgment, tap, alternate bond, $2,500. And sir, you have to stay away from this location. You cannot be anywhere near 255 East Flagler Street, Miami, Florida, within 500 feet. Do you understand that?
Okay, so yes, I understand that.
Good luck.
It's the same as what you had. Yes.
Devin Alberto.
Refuse, Court, Your Honor. Reset for tomorrow.
Okay. June 1st. Braxton Menendez or Mendez.
He also refused, Court.
June 1st. Ernest Smith.
Your Honor, they were here, but the transportation took them back, so it's on NBC.
Why did they do that? June 1st. Is that for the rest of them?
It's for Mr. Roll
Roll as well.
also.
So that means we're gonna have a busy calendar tomorrow. Busier. I thought this, you guys told me this was a light calendar?
Not bad. This is still not bad. Yeah.
Wow. Okay, so June 1st, 25 for roll.
The state is right. This is still pretty early in recent times.
Yeah, I guess so. I just gotta go through it. Malhotra Gaurang, same
Oh,
thing.
yeah.
Not
Gaurav is a bond out.
Oh, he's a bond out. Made it out, okay. Yes. Abdul Anthony.
He refused, Court, Your Honor.
Refused, not brought to court. June 1st, 25. Manley Guerrond.
Refused also.
June 1st, 25. Terry McClinton.
Refused.
June 1st, 25. Luis Gonzalez.
Also refused.
What'd you say?
He refused also, Your Honor.
Oh, I was listening. What did you say?
I'm gonna have a big count.
Yeah, we're gonna have a big calendar tomorrow. We're all in this together. What was it? Carlos Barrios.
Refused.
Arias?
No, this is Mackenzie.
That they just called.
Oh.
Yeah, they're just going through the Patterson.
First 25. Tony S. Clark.
Refused.
Juan McKenzie.
Yes, Your Honor.
All right, that's you. Okay. Mr. McKenzie, we've got a couple of cases. You are charged under case number F25-11085 with domestic battery by strangulation, also 1 count of battery and 1 count of assault. I'm reviewing the arrest affidavit. Try to find the probable cause for the assault. Yeah. Anything?
I guess when the defendant approaches the victim's vehicle, raised hand. Let's see. Right. Okay. There we go. All right. So okay. Slapped her with an open hand and then stated he was going to kill her. So that coupled with.
Where is that?
Okay. So
I see it.
page 2.
Left side of the page. With an open hand cousin is so cool. All right. Okay. The court does find probable cause on all 3 counts. And I'm now going to take a look at the other A form, F25-11086. You are charged with written threats to kill cause bodily injury and threatening or harassing phone calls. If the court does find probable cause, dealing first with the F-25-11085 as to count one, $5,000, as to count two, $1,500, as to count three, $1,000. Then as to F-25-11071.
I don't have F-25-11071. I have 11086.
And
Oh, wait, forgive me, wait, it's a 11086. I was pulling the wrong A form. As to F-25-11086, as to count one, $10,000, as to count, actually, you know what, $7,500, as to count two, $5,000, $1,000.
Would the court consider an alternate of house arrest standard conditions? I don't think that he had any local priors. He does have an aunt that he can stay with. That would not be with the alleged victim, and he could get out on a monitor.
No, I'm going to be adding the house arrest. It's not going to be in lieu of. On all of these counts, there will be a GPS house arrest. I will give it level 2, allowing him to work on all counts.
Both cases, correct?
Correct.
But she is indigent. Just questioning the purpose of the monetary bond, given that he probably can't afford it. It could be tantamount to no bond.
These are serious allegations. I'm not just giving a house arrest. Mr. McKenzie, you cannot have any contact whatsoever with Jasmine Henry. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate with her through a third person. Do you understand, sir?
Yes, sir.
Now, is there a shared home where you have some personal belongings or no?
Yes, sir.
All right, I will allow you to go to that home within 48 hours from your release, and with the accompaniment of a law enforcement officer to get your personal belongings. Good luck to you, sir.
Okay, sir.
Mr. Victor?
Then we go to Victor Jose.
Good afternoon.
All right, sir, you're charged with the domestic battery by strangulation and battery. Reviewing the arrest affidavit.
I do have a probable cause argument for this case as well.
I'll hear your argument.
They're conflicting stories here. Given that the alleged victim is saying one thing and the defendant is providing an explanation for the other. The grandmother was also present, apparently as a witness. None of her statements are read into the arrest affidavit. So at this point, we have two reasonable circumstances. I'm not sure what the police did to determine who was the initial aggressor, since there's no mention made of if the grandma who was there gave them any testimony about that. But from what Mr. Jose is saying, it was the alleged victim that was the initial aggressor, and he was trying to calm her down, and then he was hit by her aggressive force. from the piece of door, she also admitted to using the door to scratch him.
All right, state.
Your Honor, the victim stated the defendant placed a chokehold from the back, preventing her from breathing, which they were throwing around the neck area. And that was consistent with her statement. But you know, conflict in whatever story, the officers were able to see that this around the neck area on this victim version.
Yeah. Look, there many times are going to be conflicting stories. The officers on the scene were the ones who interviewed the witnesses, and they wrote what they believe to be the probable cause, and the court is reviewing that. And in the four corners of this affidavit, the officers wrote the defendant was determined to be the primary aggressor, and the court does find probable cause as it relates to count one. It is $5,000. Count two, it is $1,500. With both of these counts, does he have any priors? I need to find out. In the meantime, Mr. Jose, you are to have no contact whatsoever with Leslie Fernandez. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media to attempt to communicate with her. Now, do you have property within the residence where she's living?
Yes, that's where I live. That's my
Okay,
home.
you're gonna need to find another place to live, but you will have the ability to get your personal belongings out of that home with the assistance of a law enforcement officer. What did you find out? Anything?
So, you know, it appears the only thing that you have is an open carry system.
Okay, all right, the court will not order any GPS. It'll be a straight $5,000 and $1,500 on those two. Good luck to you, sir. Eduardo Fernandez, I think, is this our last one? Yes.
Mr. Fernandez is a violent felony offender, special concern. He is in custody on a felony probation violation, no bond.
Okay, what is, what case
It's
is,
F25239.
and who's the judge?
Sorry, Your Honor.
It is Lodi Jean.
Lodi Jean, okay?
Good morning, or good afternoon.
Afternoon.
Morning, Gene.
Battery on a person 65 years of age or older. Also possession of cocaine and possession of drug paraphernalia with intent to use. I'm reviewing the arrest affidavit.
You don't, I don't disagree or anything.
And I
Honor.
don't suggest that he speaks on the record. I did have a probable cause argument as to the battery on elderly individual. For Mr. Fernandez. This is the case I actually misspoke earlier when I meant to address a different case. I was addressing this one.
Hold on,
Here-
hold on.
okay.
Nice one, better go. All right, go ahead, Counselor.
As to the battery on a person 65 or older, Judge, there's nothing within the four corners of the arrest affidavit that I'm seeing that establishes any age, date of birth of the alleged victim. And so I'm arguing you don't find probable cause for that enhancement with the age, but I'm also arguing that you don't find probable cause for a felony battery in and of itself. There is a witness, but the alleged victim himself says that it was a dispute. It turned into a skirmish, which to me reads as a mutual combatant situation.
And also,
And that
the skirmish was between father and
excuse-
son.
and excuse me, Mr. Fernandez, and that the alleged victim himself, he refused to be transported to the hospital for his injuries.
Yeah, I'm not seeing anything about the victim's age here. See?
As for no battery whatsoever, though, there is, here is, the defendant Bruce's victim was for victims will causing there's bruises / battery or they fall apart. However, does not appear that maybe listed where all the actual that's good. But there is probable cause that a battery was.
All right. We can do one of two things. If you, I can find probable cause as to battery, but not battery as of 65 years of age or older, and we can have a probable cause hearing tomorrow. Or if council wants to stipulate to battery on a person 65 years or age or older, then we can not have the hearing tomorrow.
I'll stipulate, Judge. That's fine.
So the court does find probable cause on all three. What, do we have any priors? Oh, this is the VFOSC, my mistake, okay. Yeah, he's being held for Judge Lodi Jean, F-25-239. As to count one, it's going to be $5,000. As to count two, $2,500. As to count three, $500. And sir, you have got to stay away in the meantime from Edward Fernandez. That means no direct contact or indirect contact. You cannot call, you cannot write, you cannot text, you cannot use social media or attempt to communicate through a third person. Do you understand?
Yes, but that's my father. I was planning on getting a ride from him home.
Okay, but again, right now you cannot contact him in the meantime.
We'll just stay away order right now. So.
Okay. I think that's it.
Is that it, Your Honor?
That is it. Thank you, everybody.
Thank you.
Okay, goodbye, guys.
Have a good rest of your weekend or night.
You're gonna get to bed tomorrow?
I hope not.
Oh, it's raining now?
Her phone says it's raining. Probably raining on one side on the street, but not the other.
Yeah, it's crazy why that happens.
I found out late.
Today's the day.
All right, I guess-